Hey, Mr. Lordship.
Let's look at it now.
Item number 38 and 39. Both these matters have become infructuous.
The Arsena Learning Council appearing on behalf of the petitioner submits upon instructions that the writ petitions have already become infructuous. Accordingly, both the writ petition stands closed as it has become
Deeply obliged.
in same order if any stand.
Mr. Lordship, I'd like to mention item number 42. The engaged counsel, Mr. G. Chaudhary, is in Tejpur for his father's death anniversary. So, the engaged counsel, Mr. G. Chaudhary, is in Tejpur for his father's death anniversary ritual. Kindly adjourn the matter for the day.
Item number 42, adjourned to, at the request of the learned petitioner, adjourned to 26th of September.
Right.
Item number 1, part heard.
The council is coming from Italy. His mother was here yesterday. He started morning. He also reached his party also. Which is on the way. He reached within a half an hour time. Only for half an hour.
Lordship, I was directed to produce the records in this case. Lordship, I have received one file, but that doesn't contain the original documents. Some file has been sent that is relating to writ petition only. The original file was not received. So I pray that some time, maybe a week's time, maybe Lord, I can produce the original records.
What was the matter about?
The matter, Lordship, we issue notice under Finance Act 1994. They have challenged the notice on the ground that after the rolling of the GST under Section 174, the notice is bad. And this issue has already been decided by our High Court. Lord. And our another ground is that since only notice has been issued, they have alternative remedy. They can avail that, Lord. And in the meantime, our High Court as well as Delhi High Court decided this point also. If you got original records, Lordship, I required a week's time.
Why do we require a record?
Lordship, on last occasion I was not there. Lordship,
The
first
record
order that
pertaining to demand come notice is also required to be looked into. You don't have the record.
Lordship, I received one file, but that doesn't contain the relevant notices and satisfaction of the department for issuing the notice. Although it is relating to this case. Lordship, a week's time, say on 7th or 8th or 9th, Lordship, maybe.
But normally he's coming. 10 to 20 minutes. That may be quick. The council is coming.
Okay. Take it up at 2.
2 p.m.
At about 2. Yeah. Recovery of debt.
This is the DRT jurisdiction.
Hmm?
DRT jurisdiction matter.
Yes, I know. Now the DRT Act stipulates that the Limitation Act will apply.
Yes, yes.
So under such circumstances, benefit of section 14 you can get.
And I have also found a judgment, Your Lordship, which 1005 SCC 355 says that the court under section 14 of Limitation Act should be liberally interpreted. It is not civil court.
Understood, but whatever may be, I think the CPC, the Limitation Apply Act has been made applicable where in the DRT Act has been made.
Thank you.
Section 24, your Lord, of the
Section 20.
Yes. So in view of section 24, you'll get the benefit.
No.
There's no other way out.
Not apparent, your lordship, they should have your lordship.
By way of.
By way of a notification that they have.
You cannot. Hey, move that, So we have to direct the DRT to return the application to you for filing.
Sure.
Isn't it?
Sure.
Or would it be filing it afresh?
We'll have to file ultimately express your lordship before the competence. Is the proper
Best
plan.
would be to return it. Let it be returned by them so that you can file it in the proper as per the procedure.
And that liberty your lordship observed that the due diligence your lordship we have.
So that I will mention. No, that I am giving it. The only thing is, see, that day I got hold of a judgment, of a recent judgment of the Supreme Court. We'll be exercising the writ of sorcery. Now, says that there are two cardinal principles. The first one is this, and the second one is very relevant, which may be made applicable here. Is that the second cardinal principle of exercise of extraordinary jurisdiction under Article 2 to 6 of the Constitution is that in a given case, even if some action or order challenged in a writ petition is found to be illegal and invalid, the High Court, while exercising its extraordinary jurisdiction, therefore, thereunder can refuse to upset it with a view to doing substantial justice between the parties. That is one part. Article 2 to 6 of the Constitution grants an extraordinary remedy, which is essentially discretionary, although found on legal injury. It is perfectly open for the writ court exercising this flexible power to pass such orders as public interest dictates and equity projects. The legal formulations cannot be enforced divorced from the realities of the fact situation of the case. While administering law, it is to be tempered with equity, and if the equitable situation demands, after setting right the legal formulation, not to take it to the logic that the High Court would be failing in its duty if it does not notice equitable consideration and mold the final order in exercise of its extraordinary jurisdiction. Any other approach would render the High Court as a normal court of appeal, which is not.
Very recent.
Yes. Because I was thinking about how do you bring 14? If it's a writ petition, you can't bring a 14. But you can bring a 14 because the Limitation Act is made applicable to the tribe. That is the only way out. What is that judgment you are referring to?
It says your lordship.
It is before a tribunal.
Yes, your lord. It says it will be noticed that section 14 of the Limitation Act does not speak of a civil court, but speaks only of a court. It is not necessary that court spoken of in a section 14 should be a civil court. Any authority or tribunal Having the trappings of a court would be a court within the meaning of this. There are 12.
The instant repetition is filed challenging the communication dated 1/8/2019 issued by the respondent number 3, that is the Undersecretary to the Government of India, Ministry of Finance.
Lordship, this was issued because of this claim.
And also the original application number 97/2019 pending before the Debt Recovery Tribunal, Guwahati, should not be transferred to an appropriate civil court having jurisdiction over the subject matter. The facts involved in the instant case is that Section 1(4) of the Recovery of Debts and Bankruptcy Act 1993, bracket here, formerly known as the Recovery of Debt due to Banks and Financial Institutions Act 1993, stipulates that save as otherwise provided, the provisions of the said act, that is the Recovery of Debt and Bankruptcy Act 1993, hereinafter for short referred to as the Act of 1993, shall not apply where the debt amount of debt due to any bank or financial institution or to a consortium of bank or financial institution is less than 10 lakhs or such other amount being not less than 1 lakh as the central government may by notification specify. It reveals from the records that the central government had issued a notification in exercise of the powers under subsection 4 of section 1 of the Recovery of Debts Due to Bank and Financial Institution Act 1993 as it stood then. Whereby the central government specified that the provisions of the Act shall not apply where the amount of debt due to any bank or financial institution or to a consortium bank or financial institution is less than 20 lakhs. It is also seen from the records that the said amendment it is also pursuant thereto it is also seen from the records that the same notification dated 11th, dated 6/9/2018 was put to challenge before the Rajasthan High Court in a writ petition being registered as DD CWP number 21860/2018. The Rajasthan High Court, by an order dated 26/9/2018, state the notification dated 6/9/2018 thereupon by an order dated 1/7/2019, the said writ petition was dismissed. In view of the stay granted by the Rajasthan High Court, by an order dated 26/9/2018, a situation arose as to what could happen during this period. From 26/9/2018 to 36/2019. The said aspect of the matter was deliberated with by the Ministry of Law and Justice, Department of Legal Affairs, and taking into account the judgment of the Supreme Court in the case of Sri Samundi Mopeds Limited versus Church of South India Trust Association, Madras, reported in AIR 1992 SC 1439. An opinion was expressed by the Ministry of Law and Justice, Department of Legal Affairs, that a conclusion can be safely drawn that the cases having suit value between 10 lakhs and 20 lakhs, which were filed before the DRT during the stay period, may continue stay period, that is, from 26/9/2018 to 36/2019, may continue in the DRT till conclusion, so that no prejudice shall be caused to the parties who have filed such suits in good faith. This very opinion, this opinion, which was rendered by the Ministry of Law and Justice, Department of Legal Affairs, was submitted during the course of the hearing by Mr. S.S. Roy, the learned, what do you are?
CGC.
Learned Central Government Counsel, which is kept on record and marked with the letter X. This court further finds it relevant to take note of another development thereupon. Another development in the meanwhile, prior to the opinion being rendered by the Ministry of Law and Justice, Department of Legal Affairs. By another notification dated 11/7/2019, the Ministry of Finance, Department of Financial Services issued a notification in exercise of the powers under subsection 4 of subsection 1 of the then Recovery of Debt due to Financial and Bank and Financial Institution Act 1993, whereby the notification dated 6/9/2018 was amended the effect of the amendment so made by the notification dated 11/7/2019 is that after the words inverted comma is less than 20 lakhs inverted comma close, after the words is less than 20 lakhs occurring in the notification dated 6/9/2018, the following words were added, oblique inserted, inverted comma, but shall continue to apply to the debts in respect of which an application for recovery has been filed before the debt recovery tribunal prior to the date of publication of this notification. That is to say, comma, the 6th day of September 2018. Therefore, by the said amendment, by the said notification, dated 11/7/2019, those cases which were filed, those applications which were filed for recovery before the debt recovery tribunal prior to the publication of the notification dated 6/9/2018 the effect of the is that the effect of the said amendment the inverted comma close. Also, were saved and there was no requirement and was saved, and thereby the jurisdiction of the debt recovery tribunal in respect to those cases below less than 20 lakhs filed prior to 6/9/2018 shall not apply. Next, as already stated, an opinion was expressed by the Ministry of Law and Justice, Department of Legal Affairs, on 18/7/2019, wherein it was mentioned that the cases having the suit value between 10 lakhs and 20 lakhs, which have been filed before the DRT during the stay period, that is from 26/9/2018 to 36/2019, may continue in the DRT till conclusion. On the basis of the said opinion rendered, the Deputy Secretary to the Government of India, Ministry of Finance,
Yes. Yes.
Ministry of Finance had issued a clarification on 1/8/2019, clarifying that the cases having suit value between 10 lakhs and 20 lakhs, which have been filed before the DRT during the stay period, that is from 26/9/2018 to 36/2019, may continue in the DRT till conclusion, so that no prejudice shall be caused to the parties who have filed such suit in good faith. It was also mentioned that cases filed on or after 1/7/2019 may be transferred to the civil court by the DRT. This clarification, which was issued by the respondent number 3, have been assailed in the instant writ petition. The reason why the said clarification has been assailed is in view of the fact that when did you file this suit?
So they have filed it on,
No, he filed.
12/3/19.
12/3/19 before the DRT.
The reason why the said clarification has been challenged is in view of the fact that on 12/3/2019, the respondent number 2 had filed an application under the provisions of the Recovery of Debt due to Banks and Financial Institutions Act 1993, claiming an amount of rupees
13 lakhs.
claiming an amount of rupees 13,28,647.04 along with interest at the rate of 12.80% from 1/10/2018 till realization. It is further relevant to take note of the said application was registered and numbered as original application number 97/2019. To the said application, the petitioners have filed their written statement. And had also taken a preliminary issue as regards the maintainability of the said writ petition, the said application. In view of the notification dated 6/9/2018, The instant writ petition was filed on
12 March.
10th of March 2021. And this court, by an order dated 19/3/2021, stayed the further proceedings of OA number 97/2019 pending before the Debt Recovery Tribunal, Guwahati. It reveals from the records that the respondent number 1 and 3 had filed an affidavit in opposition stipulating that reasons why the impugned clarification had to be issued. By the respondent number 3. A perusal of the said affidavit in opposition shows that the reasons assigned are similar to the reasons as was opined by the Ministry of Law and Justice, Department of Legal Affairs. I've heard the learned counsels for the parties and perused the materials on record. It is also relevant to take note of that an affidavit in opposition was also filed by the respondent number 2 bank, stating inter alia that in view of the stay granted by the state, in view of the stay of the notification dated 6/9/2018 by the learned by the Rajasthan High Court in its order dated 26/9/2018, and the jurisdiction of the Debt Recovery Tribunal was 10 lakhs and above. And as the claim of the respondent number 2 was 13 lakhs and odd, hetu amount was, no? 13 lakhs. The Debt Recovery Tribunal had the jurisdiction to entertain the said proceedings. I've heard the learned counsels for the parties and have also perused the materials on record. The issue which arises, the issues which arises for determination by this court is, number 1, whether the respondent number 3 could have, by way of a clarification, amended the notification issued under subsection 4 of section 1 of the Act. Number 2, if not, what orders can be passed in the instant proceedings? These are the two. This court, for the purpose of deciding the first point for determination, finds it apt to reproduce the provisions of subsection 1 of subsection 4 of section 1 of the Act, which is as hereinunder. To quote to it, subsection 4. As already stated, supra, unless it is otherwise provided in the Act unless as otherwise provided. The provisions of the Act shall not apply where the amount of debt due to any bank or financial institution or to a consortium of banks or financial institutions is less than 10 lakhs or more, or such other amount being not less than 1 lakh, as the central government may by notification specify. The use of the words as the central government may, as the central government may by notification specify, inverted comma close, makes it clear that the specification has to be made by the central government by way of a notification and not on the basis of a communication issued by the respondent number 3 to the registers to the debt recovery tribunals. As already observed herein above, by the amendment made by notification dated 11/7/2019, only those cases were saved from the notification dated 6/9/2018, which were filed prior to 6/9/2018. This court have also duly taken note of the well-settled principles as regards a stay so granted, as regards the effect of stay in respect to the notification. As observed by the Supreme Court in the case of Chamundra Mopeds, a stay of an order or a notification
There are 10 of that depth.
only eclipses the order or notification for the time being till such stay order persists. The Supreme Court had also made it clear in the said judgment that a stay of an order or a notification does not mean that the said order has been wiped out from the existence. Under such circumstances, the stay which was granted by the Rajasthan High Court in the DB so and so number on 26/9/2018 only eclipsed the notification dated 6/9/2018 till 36/2019. Inasmuch as on 1/7/2019 the writ petition was dismissed. The moment the writ petition was dismissed, the order dated the notification dated 6/9/2018 becomes operational from the date it was made effective. Under such circumstances, this very notification would not have been modified or changed unless otherwise in accordance with the provisions of subsection 1, subsection 4 of section 1 of the Act, as has been done in the case of as was done by the notification dated 11/7/2019. In that view of the matter, it is the opinion of this court that the said notification, the said clarification so issued by the respondent number 3, said clarification so issued by the respondent number 3 on 1/8/2019 is contrary to the provisions of subsection 4 of section 1 of the Act, and accordingly stands set aside and quashed. Now coming to the second issue, point for determination as to what relief can be granted to the petitioner, to the parties before this court. As I already observed, that said notification, clarification, oblique the communication dated 1/8/2019 is set aside and quashed. The effect of quashing the notification, the communication dated 1/8/2019 would make the writ petition, the original application, would render the Debt Recovery Tribunal Guwahati would oust the jurisdiction of the Debt Recovery Tribunal Guwahati to adjudicate the application filed by the petitioner by the respondent number 2, being original application number so and so. This court, even after perusal of the entire provisions of the Act, does not find a similar provision this court, upon perusal of the provisions of the Act, this court, upon perusal of the provisions of the Act, do not find a provision which is parameter to section 31 of the Act, whereby the tribunal, any proceedings pending before the tribunal can be transferred to the civil court. Inasmuch as a perusal of section 31 of the Act only stipulate the transfer of pending cases transfer of suits or other proceedings pending before any court immediately before the date of establishment of the tribunal under the Act to the tribunal. This court finds it relevant at this stage to refer to a recent judgment of the Supreme Court in the case of Central Council for Research in Ayurvedic Science and another versus Bickerton, Das and others reported in 2023 SCC Online SC 996, wherein at paragraph number 51 and 52, the Supreme Court discussed observed that there are two cardinal principles of law governing exercise of extraordinary jurisdiction under Article 2 to 6 of the Constitution, more particularly when it comes to the issue of a writ of certiorari. The first cardinal principle is that the court exercising the jurisdiction under Article 2 to 6, the High Court, while exercising the jurisdiction under Article 2 to 6, does not exercise the powers of an appellate tribunal. The jurisdiction of the High Court, by exercising the jurisdiction under Article 2 to 6, the High Court demolishes the order which is considered to be without jurisdiction or palpably erroneous, but does not substitute its own views for those of the inferior tribunal. The second principle, which is rather important for the purpose of the instant case, is that it is open for the writ court exercising its flexible powers to pass such orders as public interest dictates and equity projects. It was observed that the legal formulations cannot be enforced divorced from the realities of the fact situation of the case. And while administering law, it is to be tempered with equity. And if equitable situation demands, after setting right the legal formulations, not to take to its logical end, the High Court would be failing in its duty if it does not notice equitable considerations and mold the final order in exercise of its extraordinary jurisdiction. It was observed that if such an approach is not adopted, it would render the High Court, it would render the status of a High Court exercising jurisdiction under Article 2 to 6 a status of a normal court of appeal, which it is not. In that view of the matter, taking into account the above principles as set out by the Supreme Court, and this court having found that the communication dated 1/8/2019 to be without jurisdiction, have, in exercise of the powers have, by issuing a writ of certiorari, have set aside the same, also finds it relevant that the respondent number 2, who on account of the stay order passed by the Rajasthan High Court, thereby staying the notification dated 6/9/2018, had filed the proceedings before the debt recovery tribunal, cannot be non-suited for want of jurisdiction pursuant to the dismissal of the writ petition pursuant to the dismissal of the writ petition and the notification dated 6/9/2018 becoming effective from its original date. However, as already observed, there is no provision in the Act thereby empowering the debt recovery tribunal to transfer the case to the civil court. Nor by operation of law the case can be transferred. The case filed by the petition respondent number 2 can be transferred to the competent civil court. Under such circumstances, this court therefore disposes of is of the opinion that the interest of justice would be met if a direction is given to the debt recovery tribunal, Guwahati, to return the application to the petitioner within 10 days from the date of submission of the instant certified copy, and thereupon granting the liberty to the petitioner to file a suit, to file the same by following the as per the in the applicable format before the competent civil court. This court also finds it relevant herein to observe that Section 14 of the Limitation Act would be applicable. Limitation Act 1963 would be applicable in the present situation to the petitioner, to the respondent number 2, taking into account that as per Section 24 of the Act, the Limitation Act has been made Act of 1963 has been made applicable to the debt recovery tribunal, as well as also taking into account the judgment of the Supreme Court in the case of P. Sarathi versus State Bank of India, reported in 2005 SCC 355. Accordingly, the instant repetition stands disposed of with the following directions of observations and directions. Number one, the impugns clarificatory communication dated 1/8/2019 stands set aside and quashed. Number two, the respondent number 1 and 3 is directed to pass appropriate is given the liberty to issue appropriate notifications, thereby further amending the notification dated 6/9/2018 for taking care of those cases filed during the stay period given by during the stay of the notification dated 6/9/2018. Number 3, the Debt Recovery Tribunal Guwahati is directed to return the original application bearing number so and so to the petitioner, to the respondent number 2, upon a certified copy of the instant order being produced before the register, before the register of the Debt Recovery Tribunal. The respondent number 2 is further given the liberty to file the said returned application in the proper format before the competent court of jurisdiction, and the period of limitation from the date of filing of the application till the date the file is returned shall be excluded while computing the period of limitation with the above the instant.
Obliged.
Anything else? Mr. Bhattakur?
Obliged.
Number 3.
Last petition instruction is up for deputy commissioner.
Yes,
Yes, sir, very civil, sir.
let them apply.
They will apply, then they will consider in terms of present length. Second phase.
You apply. Until then, you shall not be evicted.
Right.
Till your applications are not disposed. That's all. And you are to apply within
Within
30 days.
Time frame.
Okay.
So we want to make some submission of it.
Yes.
Because this person is not number 1. Adjacent to her home, there is another problem which is settled land. They have pata land. Therefore, if those people can say the same situation, why person have taken?
Huh?
If, the adjacent plot of land, there is a pata land. Same position. Same distance from the river. So if those persons can stay there, right? The petitioner number 1 can. That's why I want to. Because
Okay.
I want to. Affidavit.
No, we dismiss that. As you are for petitioner number 1, then we dismiss it on that. And madam, you are paying for which petitioner?
1 and 2 recently he did it.
Huh?
For-
One with petition, the lawyers are different.
He has not filed
I
any
don't know.
Allotment. He has not filed in Wakalatnama.
Wakalatnama, my lord.
I
And
wish
they
to-
did not inform me, my lord.
Without Wakalatnama, how can?
You have not filed wakalatnama and what is? Huh?
I have already filed it this morning.
Hello, we take it that year. Well, now you have the filed the wakalatnama for how many petitioners? How can you file for two?
Yeah.
Tell me.
Hmm.
Have you taken the no objection from her?
No, my
They gave consent.
not yet. I have not.
No, no, I don't understand. In one matter, how can you file for two? We refer this to the bar council.
No, Lord.
No, we'll refer this to the bar council. It is required. Because in
The
one
petitioner
petition,
inform me, my lord. He
where
has
two persons is appearing for two persons, there are 11 petitioners for
11
2%, another advocate is appearing. How is it possible? Unless you have taken consent.
I took consent, Lord.
And we'll take the, let the bar council decide that. So these two petitioners, if you are appearing,
Petitioner also did not inform me. my lord. Petitioner should inform me.
I just withdraw my Wakalat.
you have to. You can't take it like this. Without their consent on writing, how is it possible?
And
Not
they were
heard of.
informed by the petitioner, but they also did not inform me.
Yes, see. The petitioner herein, the 11 petitioners have joined together to file and have joined together and have filed the instant writ petition seeking a direction upon the respondents to consider the case of the petitioners for settlement of allotment of their respective lands, taking into consideration that the allotment of settlement of the land in some other persons have already been done in terms with the circle officer's report, annexure Roman 4. And as to why their settlement, as well as for in some other persons have been done in terms with the circle officer's report.
My lord, one Kiranbala Devi also, my lord, considered by the LH. Page 24.
The petitioners have also sought for interim directions that the respondent number 3 should be restrained not to take any steps in pursuance to the notice dated 13/6/2017. The record reveals that the petitioner, the record reveals that it is the case of the petitioners that they are in occupation of certain lands since 1980 and had applied for allotment and providing patta. It was alleged that the Land Advisory Committee time and again had taken steps for allotment of those lands to the people occupying these wetlands who are landless. It was also the claim of the petitioners that annual pattas were distributed to some petitioners who are in possession till now by paying revenue to the government. And one of such petitioner is the petitioner number 4, who had paid her land revenue as annual patta holder in the year 2000 as annual patta number 137. Hmm. However, it is relevant to observe at this stage that from a perusal of the said Annexure 1, which the petitioners claim to be a revenue paying receipt by the petitioner number 4 on her annual patta, would show that it is a Tozi Moja. It is a Tozi paid by the petitioner number 4 in respect of annual patta land in respect of
Action, patale.
annual patta land 137. So, it is relevant to observe that Tozi Moza or Tozi Maza is actually a penalty for occupation of government land. Be that as it may, the petitioners further claim that the Land Advisory Committee of Nagaon Subdivision on 29/12/2013, in presence of all members, passed a resolution for allotment of settlement to private persons, wherein some about 8 persons' names was approved for allotment settlement over dark number, wherein the petitioners are residing. It was alleged that the said land which have been allotted or settled are all in the same nature and are situated in the same row where the petitioners are residing. The petitioners also had approached the concerned minister, applying, thereby filing a representation for allotment of the land, as they are poor and landless persons occupying the land by paying government revenue. It was also alleged that one person by the name of Bigonto Bora of Nagaon was granted a settlement in favor of in his favor. It is further stated, it is further seen from the writ petition that on 13/6/2017, a notice was published under the signature of the Deputy Commissioner Nagaon in the Assamese Daily, Niamia Bota, wherein it was mentioned that some people illegally occupying wetland of Kolong, Mori Kolong, Kuta Kolong, and thereby violated the law and also has caused destruction of the natural beauty and have also caused free flow water flow. It was mentioned that the administration have decided to evict them if they don't vacate the land within 15 days from date of receiving the notice. It is under such circumstances the instant writ petition was filed, seeking the reliefs as already mentioned herein above. This court, by an order dated 12/7/2017, issued notice, and it was provided that until returnable date, status quo in respect to the land under the occupation of the petitioner would be maintained. The record further reveals that an affidavit in opposition was filed by the respondent number 2, that is the joint secretary to the Revenue Department. In the said affidavit in opposition, it was mentioned that the government of Assam presently has a land policy 2019. Reference was made to clause 14.6 of the land policy 2019, wherein it has been mentioned that allotment / settlement of land in notified water bodies / hills, ecological sites, and vulnerable to landslide, erosion, etc., shall not be considered. It was mentioned that the petitioners are occupying the land adjacent to Kolong River, flowing through Nagaon town. As such, the land occupied by the petitioners cannot be settled / allotted in the name of the petitioner. It was further mentioned that regarding allotment / settlement of land adjacent to water bodies, the Revenue Department had issued circulars on 7/8/2009, 1999, 7/8/1999, and 6/9/2012 to all deputy commissioners / subdivisional officers / settlement officers, etc., with a request not to send any allotment proposal of such water body in the name of any individual, group, or organization for any purpose, and also requested to clear encroachment, if any, from such water bodies. The record further reveals that an additional affidavit in opposition was filed by the respondent number 3, through the Assistant Commissioner Nagaon. Yeah, Nani. তার আগতে লিখিব লাগিব দেই ডিকশনারি I'm coming in 5 minutes. To take note of an affidavit in opposition filed by the respondent number 3. In the said affidavit in opposition, it was mentioned that there has been no allotment orders passed by the government in favor of the petitioners. There was a specific mention as regards the respondent number 4 to the effect that no allotment and subsequent settlement has been made in her favor by the government. Further to that, it was stated that it is a matter of record that the last annual patta of town Norton under town Moza was annual patta number 65, which was eventually converted to periodic patta. And there is no annual patta number 137 in Norton Kisam. In reference to the resolution date numbers 64, 65, and 66, to which reference was being made in the writ petition, it was mentioned that the translated copies enclosed to the writ petition is not the actual translation of the resolutions so adopted, the resolutions number 64, 65, and 66, enclosed as annexure 2 to the writ petition, Roman. It was further mentioned that there is no record of allotment made in favor of Diganta Bora in tag number 300 of town Norton of town Moza. It was mentioned, it was stated in paragraph number 9 that a report which have been enclosed by the petitioner as annexure Roman 4 is not the circle officer, is not of the circle officer as mentioned in the writ petition, but that of the lot mandal. This court further finds it relevant to take note of an additional affidavit filed by the respondent number 3 on 9th of August 2023. The contents of paragraph number 3 of the said additional affidavit is pertinent for the disposal of the instant petition, for which the same is reproduced hereunder, running page 67 of the paragraph. From above quoted paragraph 3, it reveals that dark number 300 has been shown as unclassified government wetland and in the remarks column of the chita, it has been shown as inverted comma Kolong Nodi Balisat, Balichat. As regards dark number 301, it has been shown as unclassified government wetland, and in the remarks column of the chita, it has been shown as inverted comma Kolong Nodi. In respect to dark number 303, it has been shown as unclassified government grazing reserve land, and in the remarks column of the chita, it has been shown as grazing reserve. In the backdrop of the above pleadings, this court have also heard the learned counsels for the parties. This court further finds it relevant to observe that when the matter was listed on 9/8/2023, this court, taking into account the affidavit in opposition filed by the respondent number 3, sought for instructions as to whether the petitioners could be settled or could be granted settlement oblique allotment in other lands for the rehabilitation. Today, when the matter was taken up, Mr. S. Dutta, the learned counsel appearing on behalf of the Revenue Department, had produced an instructions issued by the Joint Secretary to the Government of Assam Revenue and Disaster Management Settlement Department, wherein a communication issued by the Additional District Commissioner Revenue Nagaon to the Joint Secretary dated 25/8/2023 was enclosed. In the said communication, it was mentioned that the petitioners can be settled in other lands if applied for in the district of Nagaon as per existing land policy and subject to the approval of the Subdivisional Land Advisory Committee, Nagaon Subdivision. The said instructions are kept on record and marked with the letter X. This court further have also taken note of the land policy of 2019. Clause 6.1 of the land policy (2019) stipulates that the Deputy Commissioner shall make necessary endeavors to preserve the existing DGR and TGR. TGR is
Public is
not public, TGR, for use by the members of the public for the purpose for which those were constituted, and encroachment in BGRs and TGRs, if any, would be removed.
professional gazette reserve.
It was also mentioned that the land under VGRs and PGRs will not be further decreased by way of de-reservation and allotment, etc., except for public purpose under special circumstances as defined by judicial pronouncements. In clause 6.5, it has been meant of the land policy, it is mentioned that the Deputy Commissioner shall ensure that the wetlands remain free from encroachment and the natural water channels which function as natural drainage are marked by land record staff in the village map, and note to that effect shall be recorded in the remark column of field index register bracket Chita. It was further mentioned in the said clause that the Deputy Commissioner shall not change the class of wetlands in the land records without the prior approval of the government. Clause 14 of the land policy 2019 stipulates the settlement and reservation of lands in towns. In terms with clause 14.6, allotment / settlement of land in notified water bodies / hills / ecological sites and vulnerable to landslide / erosion shall not be considered. Taking into account the extent EXTNT land policy 2019, as well as what has been mentioned in the additional affidavit, the contents of which, the relevant contents of which has been quoted here in above. The lands presently in occupation of the petitioners cannot be settled in their name. Under such circumstances, this court is not in a, this court cannot issue a direction to the respondent authorities. This court is not inclined to issue any direction to the respondent authorities to consider or grant settlement to the petitioners in respect to their lands presently under their occupation. Be that as it may, the petitioners claim that they are in occupation of these lands since decades. This aspect, however, would be subject to necessary verifications by the respondent authorities. This court have also taken note of the document and kept on record and marked with the letter X, whereby the additional district commissioner revenue of the Nagaon district had observed, had stated that the petitioners can be settled in other lands if applied for, in the district of Nagaon as per the existing land policy and subject to the approval of the subdivisional land advisory committee, Nagaon subdivision. Under such circumstances, this court, in the interest of justice, grants liberty to the petitioner to make applications within 30 days from the date of the instant order before whom? Deputy Commissioner? District Commissioner. Nagaon. Seeking settlement of land as seeking settlement of land. Full stop. If such applications is filed within the time stipulated herein, the respondent authorities shall, as per the provisions of the Assam Land and Revenue Regulation 1886, comma, the settlement rules framed therein under, as well as the present land policy of 2019, consider the case of the petitioners for settlement in other lands. It is made clear that till such applications are disposed of by the respondent authorities, the petitioners shall not be disturbed, shall not be evicted from their present place of occupation. It is, however, clarified that if within the period of 30 days from today, no application is filed, the respondent authorities can take such action as deemed proper as per the provisions of law. With the above, the petition stands.
Item number 4 to 6.
Yes, what is it? 3 petitions, 1 name. What are you doing? What are you challenging?
Petitioner is actually a firm. A firm who is working on works contract like civil and electrical fittings in the, I mean, under the Prasar Bharati.
Under?
Prasar Bharati Corporation and All India Radio, etc.
Okay, then
Then what happened? They had 3 contracts in various places for Arunachal Pradesh.
this is for release of security deposit. Why haven't you released it?
My lord, not only security deposit, my lord, actually the contract was not completed. There is a provision in the work order that 2% liquidated damage per month, maximum 10%. And in all 3 cases, my lord, he has submitted the final bill, which is below the actual. My lord, he has not completed the whole work. And we have deducted the 10% as per the provision. There are 5-6 months delay, and subsequent to that, we have called them by writing letter to have joint inspection. He has never turned back to joint inspection, my lord. And thereupon, my lord, in this case, the fixed deposit amount already withdrawn. In one case, this 816, the fixed deposit amount, my lord, he subsequently, my lord, withdrawn, my lord. And regarding, my lord, non-payment of the other amount, 10% already, as per the work order, my lord, 10% is the liquidated damage, and he has not completed the work, my lord. And I have filed a detailed affidavit, my lord. I can show, my lord. There are several requests from his side.
Where is the power of 1%? That one, clause
Liquidated-
16, page 24, page
Yes,
47, running page 47.
Yes, yes.
I'm taking up 996.
First one is 816, my lord.
996, repetition.
Okay, 996. Here, my lord. Amount
Your
is-
affidavit, running your affidavit at page 24.
Yeah.
Clause number 16.
Yes, yes, that is it.
This is the clause.
No. Clause number, that clause is,
Mr.
my lord.
Parasar, for this court to take it out, it takes 2 minutes. For a person who is reading the file, takes more.
I prepared that first item, my lord.
I have not prepared anything only. I'm
My
seeing your
lord,
file
my lord,
now.
page, my lord,
Page 24.
page
Your
17.
affidavit, page 24, running page 47.
No, my lord, page 17, my lord.
Clause 16.
Clause 13 is the liquidated damage clause.
Clause 16 is what?
16 is something else, my lord. Completion of, but my lord, page 13 of the affidavit. My lord.
Kindly come to page 24 of your affidavit.
My lord. Yes, my lord.
Clause 16.
Work compromise, yes. an amount of 1% is similar amount of director work may decide to amount of director every day. That work remains unfinished after the proper decision further to ensure good progress. Yes. The contractor shall be bound to complete 1/4 of the whole work, 1/4 of the whole time. Allotted. Yes. He left a percent of the 3%. In the event of contractor failing to comply these conditions, shall be liable to pay compensation as amount equal to the 1% or such similar amount as due to quality of the work remains incomplete provided to be paid under the provision of the clause shall not be exceed 10% of the amount. Shall not be exceed 10% of the contract money.
Yes, now tell me,
Lordship,
here use claim security deposit
yes,
along with interest. No,
Mm,
along with
yeah.
interest. Very well.
Mm.
They have not returned on the ground of imposition of liquidated damages. Have you challenged the liquidated damages?
No.
If you have not done it, how can this court say that they are wrong?
Lordship, liquidated damages has already been deducted from the final bill of whatever has been done, already complete.
So 10% has already been deducted.
Yes,
Show me that.
What is their own.
Yes, 10% deducted. Malak, in the affidavit also, Malak, we have stated page running.
We are in 996 or which one should we take? How much is the total amount? Work?
Here, total amount is 7,05,000. His final bill was 3,19,000. Page 54 of the affidavit, my lord. Total bill is submitted, my lord.
Hmm?
Page 54, 3,19,000.
3,19,000.
That is total amount was 7 lakh. And next page, my lord, page 55.
After deduction of 10% security deposit.
Yes.
Taxes, etc. Then
Then my lord, page 55, my lord. First amount is regarding that, my lord.
Hmm.
Out of 3,19,000, 2,60,000 has been paid, my lord. Deducted 10% as the money and service tax all this, my lord. And the work not completed, my lord, because
now how much can you deduct further? Is he entitled to any further deduction? Means can you say that if they don't do the work, the entire security deposit would be forfeited?
no, my lord, here security deposit is fast, my lord. I have, my lord, make peruse the calculation part.
Mr. Parasar, you kindly come to the repetition which you have prepared. Which one?
My lord, 816.
Fantastic. Facts are parameteria?
Oh, my lord, yes.
Okay. Now let us take it. Let's see the contract. Where is it?
Contract agreement is annexure 1, page 13 of
Work
the.
order is issued at page 13.
Yes, my lord.
Supply, fabrication, and so. Quotation. Total is value of the work is how much?
Here, value of the work is 15,72,000.
15,72,000.
Page 13 of the repetition.
Okay. Terms and conditions. The workmanship so additional reserves the right to reject part or whole of the supply so receive the postal if the supply is made in more than one lot so final and guarantee against any manufacturing. 10% of the order value will be retained as SD for warranty period from the date of completion.
Yes.
Okay. Terms, 80% of the material will be released after receipt of the material in good condition, the balance 20% with installation and so. Now, thereupon, these are the terms.
My lord, page 18 of the repetition, my lord, completion 90 days from the issuance of the LOI, my lord, letter of intent or.
Whichever is earlier.
Yes, my lord. Now, my lord, here page 20 is the liquidated clause was there 2%.
Page
Page 20
Hmm.
of the requisition, my lord,
clause,
13. Liquidated
the
damage for the
store work is to be supplied completed within the delivery period as mentioned above, otherwise liquidated damage for delay as per the date given below shall be applied. Normally, the LD is payable at 2% of the contract price per month, subject to a maximum of 10% of the contract price. Okay, then
My lord, work order was issued on my lord 19/2/2015.
Hmm.
And he started my lord, from my lord, it should be completed on 20th of May 2015.
Hmm.
Subsequent to that, he seek extension letter on my lord, 10/12/15 after about 5 months of that, and again on 25th of January 2016.
Hmm.
And ultimately it was extended up to my lord, 11th February 2016 in my affidavit page 40 and 41, my lord. Page 40, it is extended up to my lord, 15/1/2016 without any liquidated damage clause. We have considered to that extent, my lord.
Without any LD.
LD cost.
And
Again, my lord, page 41 is up to 29/2/2016.
complete the work a month, and here you have again extended without LD.
There it is not mentioned.
Okay, then
Then, my lord, the delay part is there, and my lord, may
serious delay in the project completion.
page 44, my lord.
Hmm.
Last line, you are once again directed to complete the work at the earliest. Several letters, my lord, there.
What is the date?
My lord, date is this 29/2.
So
Six-
that therefore the earlier period was 29/2 at page 41,
29/2.
and this is the letter of 29/2.
Again,
How much? When did you ask them to complete?
as early as possible, my lord, at the earliest. No,
So,
that
You
is
are once again directed at the earliest. Then what happened?
Then, my lord, he submitted, my lord, a part bill
Hmm.
is about, my lord, 10,83,000.
Part bill is of 6 lakhs.
That is first one is 6 lakh. First one is 6 lakh. Yeah. 6 lakh.
Then
Subsequent to that, my lord, we call him for joint inspection, my lord. My lord may come to my lord, page 52.
Hmm?
Page 52.
Yes.
My lord, the last extended 29/2/2016, but the work is still pending. You are advised that if you are not interested, then you have to you complete the rectification of incomplete work in all respect as per the work order up to 31st of May 2016 with LD clause.
Hmm.
After completion of the work, you must submit the bills along with completion certificate. No further extension. That is ultimately it is up to my lord 31st of May 2016.
Then
Then, my lord, page 56.
so then they write a letter
Then they write letter.
that you pay me 8,75,000.
Yes.
Then
Then ultimately, my
find the attachment on the above subject. Again, here what is given. Then you further extend it.
no, page 56.
That
No,
has
no,
been
no supply.
paid against the
These were some
tendered amount of rupees demand.
serial number 3, 4, 5. These works are not completed.
Okay. Page 56 says that you have already paid 10,83,669.
Yes.
Against the tendered amount of rupees 20.
Hmm.
Undersigned also analyzed the work at site and inquired about less payment.
But at that time, we have
The
deducted.
work under so-and-so feeder is so-and-so. Work under
Malad, page
work
56,
number
last.
serial number complete with other source. Serial number 3 laying of so-and-so. If you have any counterclaim, you may give a request for joint inspection of the works at mutual convenient date. After that, no request. So then, what
But
did you finalize?
that joint inspection he has not turned up, my lord. We have submitted my lord, page 56, last portion, my lord. You page 56. Well, my lord, last
Page?
portion, 56, my lord.
56. Yes, there. Yes, that I have seen it.
Yes, my lord.
Last line.
Last line, he has asked to do the joint inspection. He has not turned up. Now he is asking the money. Now, my lord, out of 10,83,000, 669, 10% was deducted, 1,08,000.
When did you deduct? You say that it is correct that rupees 10 lakhs has been paid against the tender.
Yes,
So you have paid that 10 lakhs.
10 lakh. Total bill was, he has submitted the bill, my lord, and out of that, my lord, 1,08,000 was deducted.
Where is it? How can we know that 1 lakh has been deducted?
My lord, detailed calculation I have made in paragraph, my lord. Para 16 of the, my lord. Paragraph 16 of the affidavit, my lord. Page 10, my lord. First of all, my lord, here, bank guarantee was 1 lakh 20,000. So the petitioner found unable to complete the work about 2,53,000. Out of the total work, he has not completed. Out of the total value of 15,72,000. Now, my lord, liquidated damage, my lord,
You are referring to paragraph number 10.
paragraph number 16, my lord.
What? You are not aware.
Paragraph 16, page 10.
No. Paragraph 10.
Paragraph 10, yes, that portion was given. Yes.
There. Read it.
On the basis of the petitioner's letter dated 27th of, the final bill was settled and finalized by the installation officer. The total amount of rupees 13,18,000. By deducting the earlier paid amount, earlier it was paid, my lord, 10,83,000. The difference was 2,35,114. Accordingly, 90% of the difference was paid to the petitioner on 31st of January 2017 as per the release certificate calculation details. Keeping 10% difference, that is 23,511 as the liquid damage.
Now what happened to the SD?
SD, my lord, he has, my lord, fraudulently encased the FDR, my lord.
No.
Yes, 9.
No. The thing is like this. You have finalized that he is entitled to 13,18,783. Isn't it?
Yes.
This is what you have stated.
My lord. Yes.
Out of this 13 lakhs, you have already paid him 10,83,000.
My lord.
That's clear?
Yes, 10% deduction.
Remaining is 2,35,000.
Yes.
Okay. Now, out of this remaining, you have
again deducted to 23,511.
10%.
Yes.
On that. 10% you deduct from where?
From the balance amount also, my lord. To tell.
Are you not to deduct 10% from the actual amount where he is entitled?
No. To tell 13,18,000, but first bill was of, my lord, 10,83,000, not the 13 lakh. Out of 10,83,000, 1 lakh deducted earlier.
Where?
Subsequent.
Where 1 lakh has been deducted? Where have you mentioned it? Yeah.
Para
9.
Para 9.
Yeah.
Para 9. And the same was verified installation officer. Para 9, last portion, my lord.
Against the irregularities in the completion of what was brought to the notice of the petition on behalf of the respondent on so and so. Subsequently, in inspection of the materials supplied carried out by installation as well for demand in the letter was thereafter petitioner submitted a bill of payment. The same was verified by installer and after verification of the bill amount, rupees 1 lakh so and so was deducted for future. So out of this 10,83,000, you have deducted 1 lakh.
1,08,000.
Okay. Then again, out of this 2,35,000, you have deducted 10%.
Yes, to
So in
20,500.
total, you have deducted how much?
1,31,878.
Okay. So you have already deducted 10%.
Yes.
Now, why are you keeping the SD?
Here, matlab, he has fraudulently matlab, taken back the SB. Matlab, I have mentioned in
the bank.
Oh, can you deduct any more? After
No.
these calculation, can you deduct any more?
No,
So why is he not entitled to the SD?
he is in that case, matlab, yes, he is entitled. But
That is the calculation.
Yes.
Simple.
But matlab, I have mentioned in paragraph 13, the deponent further begs to state that petitioner fraudulently encased the SB.
Not totally. It was informed by the bank. It was registered by the bank number of times.
No, whatever may be.
Yes.
He has encashed the SDR, it's a different thing. But the fact that you could only deduct 1,31,000, which you have deducted,
Deducted, matlab,
then why you are not paying him the SD? And he has already taken the SD here.
Yes,
Yeah.
in this case only.
Yes,
In
actually,
this particular
nothing
You
survives.
have
in this
already.
case.
So nothing survives
In
in
this
this
case, nothing
petition.
survives,
case.
madam.
In this case, nothing sir. And
Other two,
Other
do
two-
the same thing.
Other two,
10%.
10%
and
deducted,
double
but
jeopardy.
FD with us.
return it. Matter is there. So first has become infructuous.
Has become infrastructure. Yes.
So we, however, needs a clarification, isn't it?
Yes.
That there is no the encashment of the bank guarantee or whatever may be has no consequence taking into account that you have already deducted this. Because this will then clear up later on in any business he does.
Madam.
Because otherwise the stigma will always be there with the petition.
He's already doing other contracts in the same department.
Huh?
In other places, he's doing contracts.
Madam,
It is
he is
under
doing
the
the
same
business from Calcutta in a remote place in Arunachal. Because of that, madam, this happening.
Especially for rain. or
Whatever
wind,
we
and
do.
Not go together.
Chalo. Let me. Three, I will dispose of by one petition itself, one judgment now.
My lord.
Okay. Now I'll take the assistance of both of you
My lord.
so you can take your seat. Taking into account, no. All the three petitions are taken up for disposal by this common judgment and order. Taking into account the facts are similar and the point of law being parameterial. In WPC number 816/2020, the facts, as could be seen from a perusal of the pleadings, is that a work order dated 19/2/2015 was issued in favor of the petitioner for civil work for supply, fabrication, fixing, and installing of 120 OHM 16 wire feeder line works at 100 kilowatt MWDRM transmitter at All India Radio Pasighat. From a perusal of the said work order dated 19/2/2015, it reveals that there are various terms and conditions mentioned therein. It further reveals that the total work, that the value, that the work order, in the work order, the value of the work was mentioned at rupees 15,72,687. The period of completion was 90 days from the date of issuance of the work order or LOI, whichever is earlier. As per clause 9 of the terms and conditions stipulated in the work order, 10% of the order value would be retained as security deposit for the warranty period from the date of completion of the work. In terms with clause 13 of the work order, the liquidated damage for late delivery was stipulated. It was mentioned that the store oblique work is to be supplied oblique completed with the delivery period, within the delivery period as stipulated in the work order. Otherwise, liquidated damage for delay as per details given shall be applied. The details so given stipulated that normally the liquidated damage is payable at the rate of 2% of the contract price per month, subject to a maximum of 10% of the contract price. Security deposit কথা কলু নহয়। It reveals from the records, and more particularly the affidavit in opposition filed by the respondent, that though that the contract value was rupees 1,15,72,690, and the period of completion was on 10,
20th of May,
10 or 20,
20th of May 2015.
25, 2015.
15.
But the work could not be completed by the petitioner. There were certain extensions given without liquidated damage, and subsequently there was an extension given with liquidated damage. It further reveals that the petitioner had submitted the bill on 29/3/2016 for payment of rupees 10,83,669. And the said amount was paid after making deduction of 10% of the bill amount. it further reveals that the final bill was settled by the respondent jointly by the petitioner as well as the respondents. Was finalized by the installation officer of the respondents at rupees 13,18,783. And by deducting the earlier paid part payment of rupees 10,83,669, the differential amount was rupees 2,35,114. Upon deduction of another 10% from the said, the petitioner was paid an amount of rupees 2,11,603. Therefore, %10 of the final bill of rupees 13,18,783, that is rupees 1,31,878, was retained by the authority due to non-completion of the work. Mr. Borua, did you submit any additional amount because the security deposit comes into action by deducting? Did you-
There was some additional amount, but I don't have that calculation.
No, you deposited a bank guarantee of 1,57,000 and 10% was the security deposit, which was deducted from your bills. You see that security deposit as per clause 9 is 10% is deducted from the bills and it is kept. Now this 10% has been taken as the liquidated damage. Then how do you get the security deposit?
Then that is an extra only. Then original security deposit.
Huh?
We are.
No, you are entitled to the bank guarantee.
Yes.
That you are entitled to, but not the security deposit, because the security deposit constitutes the 10%,
Yes.
which is the liquidated damage. So in this case, you are not entitled to this 1,31,000.
We are only entitled to bank guarantee.
Only the bank guarantee. Was retained by the authority due to non-completion of the work by the petitioner. It is relevant further to take note of that the imposition of 10% of the liquidated damage on the work done by the petitioner, on the value of the work done by the petitioner, has not been put to challenge. Therefore, the deduction and retainment of the amount of rupees 1,31,878 by the respondent authorities cannot be called in question. Be it as it may, the petitioner at the time of submission of his bid had submitted a bank guarantee of an amount of rupees 1,57,269, which was 10% of the value of the contractual work. During the period however, while the disputes were going on as regards as to whether the security deposit should be paid to the petitioner or not. That's it. FDR, bank guarantee. No, it is a bank guarantee or an FDR.
It's certain bank guarantee in the form of PTR.
Huh?
It's an amount of 157 to 9.
Was it an FDR or a bank guarantee?
FDR actually.
Actually, it is an FDR.
FDR, FDR, man.
FDR, it has been.
Bank guarantee, no FDR.
FDR.
The FDR was encashed by the petitioner. Under such circumstances, it is the opinion of this court that the question of issuance of a direction out here in the instant proceedings for payment of the security deposit to the petitioner does not arise. Security deposit of rupees 1,31,878 does not arise as the same forms a part of the same forms the liquidated damage which the respondent have levied upon the petitioner for non-completion of the work in terms with clause 13. Under such circumstances, the writ which has been sought for in the instant writ petition cannot be issued. বেলেগ বেলেগকে দিব দেই থ্ৰী ৰিপিটিশ্যন নাই এইখন এখন দি দিব ছেকেণ্ডখন মোক ছেকেণ্ডখনত মই বদলাই আছো ইয়াত হ'ল আপোনাৰ নাম কেইটা লিখিছে ৱৰ্ক অৰ্ডাৰ ইজ 2010-2015 ৱৰ্কৰ কামটো আছে
Value is 7,05,000.
এইটো আপোনাৰ কেছটো 996 হা
Yes, sir. 99.
এইটো হ'ল লেকচাৰ 1তে পাব পেজ 14ত work order date to পাব what is the type of work supply fabrication fixing in lekha huh? And the total value of the work is 7,05,000 our completion period is 90 days they are going to need date to terms and conditions ofeki kotha yaha pe mention korto but whole This 70,000 was a bank guarantee or what? Again.
70,000 is FDR.
Huh?
7,500 FDR.
Again an FDR.
My lord.
Now that FDR is to be returned. That's all. Have you returned it?
No, my lord.
It's still lying with him.
My lord.
Huh?
Yes. Here, my lord, he has completed, he has submitted bill up to only 3,19,000.
That whole apna jo ase period of extension but extended from time to time he agon itna hobo. At the time of year had submitted an FDR of rupees 70,500. The total work completed was 3,19,000 as on 29/3/2016. and the total value of the work was 10% of the value যোনটো আগতে আমি দিয়া আছিল না 1,31,000. Here it will be 31,900.
31,000.
আগতে দুখন বিল ইয়াত এখন bill. সেই বস্তুটো the amount has already been taken by them, and as such সেই বস্তুটো FDR be returned to them. Only the FDR is to be returned to you. ঠিক আছে?
He is not entitled to other matlab 38,000 matlab he is not entitled to other payment. This
No,
31,000.
That amount he is not entitled to. That you have already done it. Same এইখনতো একেও. Suppose
And here matlab in the third petition matlab completion is period is 30 days only.
that will look into 30 days, and how much work did he do?
Here matlab
That is mentioned in your affidavit, na?
yes.
And how much he's not entitled to, he'll be only entitled to the FDR.
Yeah.
No interest. FDR you are already getting interest.
One only interested, either not interested.
One you have already encashed.
Encashed in first
So
case.
there nothing can be done. In the second and third, there is a direction for issuance of the FDR which is lying should be returned to the petitioner
Yes.
within 15 days from the date of receipt of the certificate.
30 days.
What do you need? It's an FDR lying out there.
It will matlab here it will be communicated to the Arunachal Pasigat matlab may take some time.
30 days. 30 days.
Pavlaj,
I know 7 to 20.
I have received the
You've got
Time, yeah, got the,
Hmm?
we need 2 weeks time to file them.
What did you get? You have only got for all the petitions.
Okay. There are 3 districts in there.
Hmm?
3 districts is there. That is one is Sibsagar, other is Sonitpur, and Jorhat. You prepare this as well, from 1/7/2017 to 12/6/2020. Date, commodity, quantity, amount of sales, name of the traders, details of the care form.
Mr. Gogoi, why don't you do one thing? Can you bring this on record by way of an affidavit? A short affidavit. Bring this on record. Then only it will be easier. Huh?
Okay.
Take this, then also they will have an opportunity. We give you 2 weeks, and in the meantime you file. Most probably you also don't have the file. As usual. Mr. N.J. Gogoi appearing. N.J. Gogoi.
Yes.
Appearing on behalf of the Assam Agriculture Marketing Board. Have placed the materials, place the details. Place the details in terms with the order dated 25/7/2023. However, this court deems it proper that the same be brought on record by way of an additional affidavit. List the matter again on,
Can I be 3 weeks? Okay.
okay, we'll have it on 21st. 3 weeks. That's the matter again on 21st of September 2023. In the meantime, the additional affidavit be filed by the Assam Agricultural Marketing Board. The petitioner shall also in the meantime file the affidavit as directed by the order dated 22/8/2023.
File your brief.
21,
No, Gondrel. Oh, madam, you are there. Where is he? This matter pertains to what?
The fixation of special rate.
This is also that special rate. Where is Mr. Kyle? We'll take it up at 2. Ask Mr. Kyle to be present. This is a matter pertaining. Have you got that order? Yeah, you don't know anything. This special rate.
Yes.
Because Mr. Kyle told me that he is going to, the order will be passed. That is why I fixed the matter after 7 days. Huh? Today.
We have not thought.
You will get it. Because then these, you are challenging some notices, I suppose, demand notices. The demand notices would obviously be changed. And also the order, if any, would also be changed on the basis of that. Yes, you got the order.
Notice lordship, we have granted.
Give me that.
Yes.
Hey, to hit the cover order display. That you have the earlier order. That order I passed na, in your favor.
And amount.
Yes. It will be a similar order type.
5 orders have been passed. For 2013-14 to till 2017.
So now this notice has to go.
Yes, Lord.
You have that, my order, you have the earlier order,
I'll provide you.
22/4/2020, or you can give me that,
In an amount, lordship,
was there any notice issued?
lordship.
Was any notice issued here?
No, lordship, they file application on the basis of application, especially it was granted.
So there is no notice.
Lordship, no, lordship, here there is no notice.
No order.
No.
Third is asking.
Lordship, page 60.
No, what is this? These rates, fixation of special rates.
Special, let us see.
It's already there. 2020, 31/8/2000 year. What is it? Hair dye. What are these documents? There is a discussion, fixation of a type copy. What is the prayer? Prayer is all same. This set of
In this
repetition.
case, lordship, notice was noticed.
Notice issued, madam. Call up your senior and find out the two, huh? A further return here to adjudicate the special rate strictly on merit without being hyper-technical. So that is gone. Has been adjudicated, according to any till date, till the has been adjudicated as the same could be contrary to demand, restraining the respondent from taking any step in pursuance to the security bond. And without deciding the special rate application of PR. Now, they have not asked for anything. They have not challenged any demand.
Yeah, nothing is, lordship, their prayer was that.
To direct the not to demand any interest, if any. Not necessary. Now, in view of these, they will, both the parties shall act on the basis of these orders.
Yes, sir.
Okay, we'll pass the order in your presence. Ask anything, any other thing, just find it out from your seat. Huh? And where is that order? Just say number two. Did you just find out? This order of Mr. Her order was 5 years. Earlier order,
That was in case of Lordship Sarath case.
Enabond.
Anabond is of the petitioner.
Huh?
That Theratek was of Devendra Sarath case. It's from
No.
See-
Devendra Saraf is only one. The only one order passed by that Dibrugarh.
Yes, Lordship, in 4 years we have allowed.
5
1 year-
years.
Yes.
1 year you did not
Yes,
on the ground of delay
Yes.
under 3-1.
Yes.
But as regards her, you have allowed.
yes, we are allowed there.
So there you have given 5 orders, separate orders.
Yes.
You give the number, we'll get out the order. Same order. But there was a notice.
Yes, in
There was
that
a
case,
demand. Now nothing is here.
here this-
Just anticipation filing it.
Yes, there is no demand.
The instant writ petition. Has been is filed by the petitioner. Taking a direction. Upon the respondent authorities to adjudicate the special rate applications filed by the petitioner in terms with what is that notification?
Notification 20 of 2008.
Huh?
There are 2 notification,
20 of
20 of 2007. Lordship. In that.
In a direction upon the respondent to adjudicate the special rate applications filed by the petitioner for the various years in terms with para 3 bracket 2 of the notification number 20/2007 CE dated 25/4/2007 and not to take any action for recovery pursuant to the judgment of the Supreme Court in the case of Union of India and others versus MS VVF Limited and another dated
20th of April 2000.
Hmm?
22nd April 2020.
22nd of April 2020. Without first adjudicating the said application filed by the petitioner. Mr. S.C. Kyle, the learned counsel appearing on behalf of the GST department, today have placed before this court various orders five orders issued by the past five orders, all dated 6/12/2021, issued by the Principal Commissioner, CGST, Commissionerate, Guwahati, whereby the applications filed by the petitioner for fixation of the special rate were adjudicated. It transpires from the said orders, which are kept on record and marked as V, W, X, Y, and Z. That for the year 2013-14, the value addition, the special rate representing value addition was fixed at 43.36%. For the year 2014-15, the special rate representing value addition was fixed at 43.39%. For the year 2015-16, the special rate representing value addition was fixed at 55.82%. For the year 2016-17, the special rate representing value addition was fixed at 56.34%. And for the year 2017-18, the special rate for value addition has been fixed at 58.29%. Taking into account that the applications seeking value addition in terms with the notification dated bearing number 20/2007 CE dated 25/4/2007 has already been adjudicated by the respondent authorities. The parties to the instant petition now shall be regulated as per the said value additions so fixed, so adjudicated upon. Accordingly, the instant writ petition, therefore, in view of the fixation of the special rates for the years 2013-14, 2014-15, 2015-16, 2016-17, and 2017-18. Have been duly fixed, as could be seen from the documents marked as annexure, marked with the letter X, Y, marked as with the letters V, W, X, Y, and Z respectively. Nothing further survives to be adjudicated in the instant writ petition. Accordingly, the writ petition therefore stands closed with the above observations. The petitioners would be at liberty to take certified copies of the letters of the documents marked with the letters V, W, X, Y, and Z.
Last order, I was directed to produce the relevant record for perusal for Lordship. But see, I
Yes,
received
you are an outstation counsel. Yes. I have directed him to produce the records. He has not got the records. He has got some other records. So he will need some accommodation. Yes, when should I fix it?
11th of September. 11th.
11th of September? 11th of September. No. Not 11th is not. 19th.
Just 39th. Can be 20th or 21 also.
21st.
20.
Taking into account that the records which were directed to be produced by this court by the order dated 14/8/2023 has not been produced by the learned counsel appearing on behalf of the GST department and have sought for an accommodation, list this matter on. No. It has to be 21st because this, I don't keep any matters for CAV. I dictate it in the court. Now, this matter I have to look into and dictate, but it is other days are motion dates. So it may not be proper because that will be. Fixes the matter on 21st of September 2023 for further consideration. This court observes that if the records as directed is not produced, this form is not produced, the instant writ petition shall be disposed of on the basis of the available pleadings. And a presumption would be drawn against the GST department. Interim order passed earlier shall continue till then.
Highly grateful.
No, 41.
Okay, Google. Oh, that one.
I have come across. Supreme
Oh,
Court
Mr. E. Gogoi,
My lord.
yesterday I could find out that 10 kilometers thing also came up before the Supreme Court, and the Supreme Court had clarified we did not declare in another subsequent order.
That was the liberty I was seeking
Eh?
to clarify it furthermore.
Because there were many other cases which went to the Supreme Court, and more particularly some other matters where not for Pubichora but for some other
There
national
was a
parks.
reserve, National Park Jhajua or something, this kind of name. It was
So
diluted.
there the Supreme Court clarified that no, we have not declared.
But there were certain guidelines I found later on of the MOEF, which has to be, that was communicated to the chief secretaries. Whatever, it's gone. It's
I
Did-
passed the judgment,
Yes.
giving them 45 days for the DC to
Yes.
decide
and
as
today
per
again-
what has been directed.
Today again, we're stuck with Ms. Godavarman again.
Yeah, did you get anything?
Yes, I get some. It's one of my. It's clerical nightmare, my lord. It's kind of clerical nightmare. Traversing all through this Godavarman judgment.
Ah.
I had to very, very specific to find out that 548.
We restrain the respondent from ordering the removal of dead, disease, dying from wind, pollen, yes, then
And then, my lord, on that basis,
now,
lordship,
how are you bringing the parks? We are
bar- my lord,
concerned with the parks.
in that view of the matter, my lord, Assam forest regulations come into play. My lord.
Assam.
Forest regulation 1891. My lord. Bark is a forest.
So this Godavaran is not there.
My lord, I'm giving it again. There was a communication from member secretary of the Central Empowered Committee. Form
And,
for
and
Godavari.
I have asked you to get the instructions on that.
And
Last
my
time
lord,
I passed an order, no?
yes, my lord. Order indicates that I couldn't produce on that day.
You are aware that the Honorable Supreme Court in IA has prohibited removal of dead, dying, so and so from any national park, so and so have been removal of grass, etc. Of the forest activity, fairly removal of biomass and activity in the your member secretary or whoever has done it, they have not stated how they are adding more than that. What is given out there by the Supreme Court,
Perhaps, my lord, he has taken recourse to an etc. word.
etc. etc. You can bring, then you bring anything also.
Etc.
Tiger also.
And moreover, my lord, this
Number
retreat,
has come to the notice of the central government by filling of trees, bamboo, digging of canals, mining underground, mining collection, transmission lines, optical fibers, protection of minor forest, raising, construction, widening of roads, etc. have been allowed to be undertaken in the protected area without obtaining permission to see that basic activities are part of the planning. To ensure strict compliance of the and none of the prohibited activities are allowed to be taken in the Then how does this will help you?
since, my lord, that order of the ECC wildlife warden was passed on the strength of that order, my lord, I am just basing it on that.
Which one?
The affidavit speaks of a, my lord, if my lord takes up the affidavit of a DFO,
That state of the records are in a very sad state. By the time it goes to the appeal, nothing will survive.
even, my lord, these barks, my lord, they are degradable and subject to decay.
Huh?
These barks, my lord, matter of dispute, this subject matter of dispute, my lord, these barks are also biodegradable, and I fear, my lord, they have survived this long, my lord.
Then what happens now? You pay them the payment amount, the value.
My lord, this is my affidavit, my lord, of the DFO. I'm handing over my copy.
You are filed there.
Yes, my lord, it is there.
Yes, the DFO, Srirang,
Yes, my lord.
I have it. That is filed on 5th of March
Yes,
2014.
yes. It refers to a letter, my lord.
Page,
It's page 7. It's fine, we put it.
inviting reference to the word of the refund.
Where is it? Oh, what is going on?
So what is your authority to do that?
Actually, my
Where
lord,
does the Supreme Court say?
yes, that was my lord, that only to justify that, my lord, I had placed that order, my lord.
But that is for grass,
And also, my lord,
grass, bamboo and all.
Assam Forest regulations for a moment.
Show me that, what does it say?
It defines forest produce, my lord.
Show me
Section 3, subsection 4,
of Assam Forest.
Forest regulations 1891.
Yes, section.
3, definitions clause, my lord, and subsection 4 therein, my lord. Park is mentioned there.
And how does the forest produce? Is there any mention about the forest produce? What is to be done as regards the forest produce?
This is an offense, my lord.
What of it?
Offense, it will result in confiscation, my lord.
Huh?
It will go to confiscation, my lord.
Have you confiscated it? No, where is it?
Section 34 of the Act. It prohibits.
No, this is with shall make use of any forest produce or any land at the disposal and not included in a reserve forest. And not included in a reserve forest or village forest. Except in accordance with the rules to be made by the state government in that behalf. Now, where is the rule?
Rules are not there.
Huh?
Rules, these rules, my lord, are not.
Rules are not there. Then how
Rules.
can you impose report?
In case, my lord, it is penalties are prescribed in chapter 8, my lord, section
Penalty
59.
for what?
If he somebody, my lord, without any authority uses, my lord, this forest produce.
But have you prescribed the rule? How can you impose penalty without rules?
There is a procedure laid down, my lord, in section 49.
Yeah. What is it?
It's seizure, my lord. Then it goes to up to confiscation.
No, understood. But unless there is a rule, how do you take care of? How are you saying that he has committed? You say, as per 34, no person shall make use of any forest produce or of any land at the disposal of the government and not included in a reserve forest or village forest, except in accordance with the rules to be made by the state government in this behalf, or as provided by the last chapter of this last part section of this chapter, or as provided the last section of this chapter. What is the last section? The last section is nothing in this chapter to prohibit acts done in certain cases. Nothing in this chapter or in any rule under this chapter shall be deemed to prohibit anything done in exercise of any right or with the permission in writing of the forest officer specifically entered to do it. So that 34 has to be read with 36 if you don't have the rule.
Here, my lord, everything started. If my lord goes to the materials in the petition, my lord, he was allowed. Everything was done. But then that communication came.
That communication cannot be the reason why.
That was the exact communication which came to the states, and it was implemented, and that transportation of bark was stopped.
That communication can't be.
And I have also in
Because the Supreme Court nowhere says about parts.
Excellent. Dead, disease, dying of wind fallen trees, tree fruit of grasses, etc. This grasses that etc. as I pointed out, my lord, that etc. word has been resorted to. And that apart, my lord, this tree.
Now, even the letter on which you have done, that's the central secretary by the central
Empowered committee, my lord.
That letter also does not say about parts.
That
You
letter
have
also
added
doesn't
the
say
parts on your own.
that etc. is the hurdle, my lord.
Now the problem arises is what happens to those goods. I've asked you to find out.
I tried to find out, my lord, and now this range has been transferred from 2019 to Manas, under Manas. It's under Manas, Kuplung range. So I have been informed verbally, my lord, that these goods have perished. These are merely, my lord, skin of a tree, which is subject to natural
understand that.
decay, my lord. So that is the position as today, my lord.
You want the skin of the tree.
And
Whatever remains.
because of that kind of collection, my lord, this tree was in Assam particularly, it was not endangered. Now it has gone to vulnerable to endangered, my lord. Over exploitation of this tree, my lord. It has medicinal properties.
Understood, but this was done at the time when it was not endangered.
Yeah, my lord.
This happened at the time when it was not
It was
endangered.
vulnerable. It was vulnerable, not that endangered. Now it has gone to endangered.
It's okay, but then it was so.
Yes.
Then you can't keep it. There is nothing, there is no rules, nothing is there. You have to do something which is as per the authority. You have seized it. Have they seized it? Have they seized it?
No, my lord, taken into custody, my lord.
Without the seizure memo?
No. There is a departmental custody order, my lord, next page 95.
File 156 additional affidavit, Lordship. At page 3 of this affidavit, it is stated.
Who has filed?
Robinson Motahari,
Got it, got it.
Yes.
Yes. What does it say?
page 3 of the inner page 3.
Regarding the status and conditions was illegally collected by the so-and-so. That is the circular of the so-and-so of the Supreme Court and orders no bark any tree is allowed for transportation.
Paragraph 8, Lordship. That based on the state report, therefore, Chirag has directed
There is
restitution
some
to-
collection that based on some allegation in connection with the illegal collection of bark. On February, the DFO has submitted report that no sufficient Bhagavad Gita stems are found as the earlier report and submitted report. He directed the range officer to visit all areas of collection and based on the demand has issued an order to seize the entire balance quantity of Bhagitala collected by Sri Vijay Chakraborty by letter dated. So based on the DFO had directed the range officer Kugro to seize the balance quantity collected by Jaya had seized demand apart from the possession of so and so on. After seizing of the AR, proposed notice was issued 2 times, but he did not receive the notice, though it was sent by speed. So no offense report to be drawn up again. Has kept the 125 bag up in his office. Now all the are deteriorated and these bags are also decomposed. So give him whatever it is. Take it, whatever it is left.
What is the fault of the petitioner, my lord?
Very well.
My lord, the petitioner has not, my lord, as per permission he has collected and once transportation TP was allowed and he transported, thereafter he collected, thereafter he applied for TP that was not allowed. And all the parks, collected parks are taken into custody. And since then it is there in their custody. And my lord, petitioner has.
At what price did you
invested-
purchase?
My lord,
What price did you purchase?
my lord, exactly, my lord, here the lump sum amount has been mentioned, my lord,
Hmm.
in my miscellaneous case, my lord,
Mistake.
833.
Excuse me.
833 of 2015, my
Eight.
page 5, last paragraph 4, my lord. My lord, last line, the applicant also then page
Page.
6, page 5, we start from page 5, paragraph 4. Page 5.
Yes.
Last line, my lord. Next, the applicant also next page 6 stated that he, being a poor unemployed person, started the said business by borrowing money from one Mr. Abdul Ali, son of so address, and approximate investment of the collected Vadgila bark is amounted to 25 lakhs. As the applicant failed to supply the Vadgila parks to the above man named Mr.
But
so-and-so,
Mr. Day, unless you show, first you are saying that you are poor, unemployed. Why will a person give you 25 lakhs?
well, their business for conducting the
So you are not
business
poor. In 2013, or 2011-12, 25 lakhs was a huge amount.
It
For a poor, unemployed person, how did you have it?
taken loan from that person. Where
You have some loan documents.
I am not a
The easy money lender, as per the Money Lenders Act. Tell me something to that effect. What is the value of the bark? To lift it. With reference to the above theory, is hereby allowed to lift 33,821 kgs of barks collected from the revenue. So there is an order also being passed by the divisional forest officer. It is okay, but what to do?
my lord, my humble submission before your lordship, my lord, since they are submitting now that the entire part amount, actual goods are damaged. So my lord, they are liable to pay compensation. And that compensation amount should be deducted by the
By the authorities.
and pay that. And as a harassment, my lord, some lump sum compensation may be imposed, my lord. Because, my lord, in 2000, from 2012, my lord, last I have collected on May.
No. I grant you the, see, as regards the compensation, if you want, give you the liberty, file civil suit of whatever may be. Your cause of action will start now. That's all. Why should I ask these authorities to decide? If these authorities are to decide, they will say only 5 rupees.
My lord, that is also.
Isn't it? They'll give you only 5 rupees for 33,831 kilos of.
My lord, they are collected from the private villagers, privately. Forest is not connected with this.
And that I realize. I've seen it. There's no question on that. But the fact that there is no documents, nothing to show that these barks, the respondent authorities have wrongly done it. So under such circumstances, and the bark is decomposed. So under such circumstances, I give you the liberty to file a suit. I'll record this and give you the liberty to file a civil suit, claiming compensation from them.
It will take another.
Ah?
Already, my lord, 10 years gone, another round of litigations, my lord, to recover.
Then how can this court adjudicate? Tell me, how can the court adjudicate? That this is the value of the barks this is the loss which has been caused to you by the business. As to how much they have seized from you, how much? 4,000 something.
No, that is, my lord, I have collected up to, my lord, May 2012. And they are.
No, they have only seized 4,300 something.
No. Kindly
What?
see, kindly see page 95, my lord.
No, from the affidavit which have been filed by them,
That affidavit, my lord, filed in 2000.
they say that only 4,375 kilos of barks have been seized.
That is collected, my lord, in 2014, as per their affidavit.
Hmm.
In 2014, but I have collected up to May 2012, which was in custody. This is subsequent, my lord, in 2014 collection only. 2014 collection only.
How can this court decide?
Earlier, my lord,
Has
page 95.
collected, yeah, now here it says the divisional forest officer with reference to the subject above, I have the honor to inform you that so and so has collected 40,000 iman from the revenue village so and 30,000 from the revenue act. As reported iman. Secondly, TP can be issued only with the destination of where only. Range officers so and so. Collection.
Total collection, my lord, your lordship will find in page 94. Page 94, 95.
Huh?
Total collection of barks, my lord.
No. In their custody
In
is
their
how
affidavit,
much?
my lord, it is pertaining to collection of 2014, my lord, only.
Mr. Counsel, how much is the quantity they have seized?
That is, my lord, page 154, kindly see. Page 154, last page of my petition.
Hmm.
With the reference to the subject cited above, I have the honor to inform you that as per a report submitted by RO, Amteka range, 39,453 cases of particulars bark has been.
Mr. Day, this particular document is also there in your miss case. I've read this. I'm only asking you how much they have seized.
All the entire amount, my lord.
Where is
This
that
page
document?
95, my lord.
Huh?
95, page 95.
Yes. Please submit the action with reference to the, please furnish the information as per remand.
And the
in a
two-phase,
notice of
two-phase,
under the
your lordship will
collection of
get.
separately, you are requested to take the custody of remand under the departmental custody. Now against
Is it
this,
two-phase, my lord? Kindly see page
Mr.
94.
Mr.
Page 94.
Day, pursuant to this communication which was issued, they say the DFO have only seized, the range officer has only seized 4,375 from the possession of the petitioner. That is what they are saying.
94, page 94, clearly stated. Two-phase. In 95, two-phase mentioned, two-phase.
Page?
It is given in
The page?
94.
94, yes.
94. Collected, my lord.
Ah.
Up to, this is up to May.
Mr. Day, this is a collection.
Collection. And this amount has to be taken into custody by page
Where is
65.
it mentioned that this has been seized? Show me this, because their specific stand is they have only seized 4,375 kilos. Show me a document which shows
My
that.
lord, they have taken into custody, not seized. As per their.
Where
my
is
lord,
it mentioned?
Order, my lord, as per their order, page 95. They are taken into departmental custody.
You are requested to take the collected so and so under until further order.
Until
That is the
further
order
order.
which has been passed. But
Yes.
how much they have taken?
And
They say that they have only taken 4,375.
4,375, kindly say, my lord, what they have, where from they are saying these things, my lord. Actually, the
So,
departmental custody taken that amount. Kindly see, my lord, para 7, in their affidavit, based on the report. On what report, my lord? Additional debit as additional PCCF, what report has been issued or order? Seize the entire balance quantity. Balance quantity, what is balance quantity of Badgila bark collected from Vijay Bosumatari By the report, it is 13. 18/12/2013, my lord. And I have collected already in 2012, May, up to May 2012. This is another matter, subsequent.
Who has seized it?
My lord, taken.
Have you got the seizure list?
No, not seized. Departmental custody taken, entire goods are taken into custody. No seizure list given.
Have you made that allegation in your petition?
I have departmental custody, they have taken.
Have you mentioned that the entire quantity of so much has been seized by, taken by the department?
My lord, I have mentioned in quick petition.
Yes, show me that.
My lord, paragraph 22, my
Hmm.
paragraph 22. That the petitioner begs to state that on 5/11/2013, the DFO Sirang Division written a letter to the principal chief forest council head of the department stating inter alia that as per the report, range officers of Amteka and Pukulung range 39,453 kgs and 46,044 kg of
Mr.
Batika
Day, this is a submission case out here which you have set out that non-issuance of the TP have resulted in decaying at your hands. Here it shows that it is decaying at your hands. Isn't it? See? But till today, no action has been taken, nor TP was issued allowing the petitioner to transport the already collected, and those are now damaging and destroying day by day.
in their custody. That's what.
Where is it? Should I add the word now with my hands?
That statement also denied by affidavit of.
No. No, in fact, they have not made that statement only.
My lord, my contention is that, my lord.
Your contention was very simple in 2013. Simple thing is that you see, I have collected all these birds and they, for whatever reason, they have not allowed me the TP for which I am not being able to use it, send it. That is the your case.
They have taken into custody all the matters.
Where have you
Well,
mentioned?
as per their order, page 95.
Again, you are referring to. Where have you stated in your petition they have taken into custody and how much?
Entire, my lord, entire.
Earlier, I have asked Mr. D. Gogoi to prepare the matter properly. Now I am going to ask you. This court can't spoil any further time with this matter. You prepare yourself properly. But an order which comes in your way is only to that effect, nothing further. Yes, they are wrong. But can this court direct other than 474375? This is the matter again on when? Mr. Day?
Next week, my lord.
Next week. When? Next week there is no time. We'll have it on 14th.
Well,
14th September. This is the matter on 14th September.
Obligation.
The file to digitize নকৰিলে নাথাকিব।
Number 22 to 28.
Lordship, maybe please to take item number 25.
What is the number?
20, WPC number 3694.
3694.
Okay, 2019.
Tell me.
Lordship, in this case,
He allowed to deposit. Yes.
Lordship, this
Yes.
Lordship, in this matter, the petitioner hearing was issued two work orders prior at the time of the VAT regime. So the work was continuing, then the VAT regime changed from VAT to GST. So this was the crux of the matter. Now, what had happened is that we had filed this petition. Since the first work order was to the tune of 50 lakhs and the second was 1 crore 12. So the estimates and everything was prepared as per the VAT regime. So we filed this petition challenging the notification which the respondents have filed in affidavit in opposition in WPC 7169.
You don't have the notification.
In my petition only, I have impugned that notification.
Where is it?
It is page 68 of my petition.
Yes. Everyone is aware of the goods and service tax.
The circular. I have impugned specific. Para C.
Era?
Para C.
C.
Capital C.
In case of work contract which are partially executed on or before 30 during the VAT tax. Where is it?
Okay.
Yes. Yes, then
Para C. Lordship, what the respondents have filed, Lordship, before the respondent had filed this affidavit in opposition, there were two dates in my petition which Lordship may, the order dated 18/11/2020
of this court.
of this,
In this case.
in this case.
Yes. 18.
11/2020
No, 18, 11, 230.
of WPC 3694.
No, there is only 8/1/2021.
8/1/21 prior the date I have the copy of
What is the order passed?
the order, Lordship, in that on the according to that order, the government were considering at a level to all the cases that fall under the in between regime, they were considering it to what would be the structure. Now,
18?
18/11/2020.
No, 18, 11, 2020.
Lordship, in my petition
There is
369,
no order in 369.
I have taken the printout. Lordship, then 8/1 may be produced. It's the same thing has been reiterated in 8/1.
Yes.
Mr. P. Gugoi, Learned Standing Council, Department of Finance, submits that there is some reconsideration of the issue at the government level.
Then
Lordship,
that is always he keep on telling make this type of submission
Lordship,
when he requires
my-
more time for affidavit.
Lordship, the point was that the 2017 circular was in existence, and in my petition, I had already made impugned. So they have filed the affidavit in opposition in item number, I think in WPC only 7169, they have filed the affidavit in opposition. Item number 23. Then they are relying on this 2017.
Let us see the affidavit in open. Now, what is your problem? Means I don't understand what is why are you aggrieved?
Lordship, my order, the work order was issued to the tune of 50 lakh, which included the tax component as well. Now I have been paying 5% VAT, which included my profit as well. Now, by virtue of this notification, the tax component increased from 5 lakhs to 13 lakhs. And I will not be getting input tax on any other because that includes labor, other sets which there is no provision for input tax. So the difference of 7 lakhs that has to tender has to be the contract has to re-enter. So that is the problem because I'm paying more tax. Now that is the profit part which would be there. Because here I'm paying out of the total taxes in my case, total taxation that I was required to pay if I was in VAT regime was 5 lakhs.
No, your contract stipulated that it was include 50 lakhs inclusive of tax.
Yes, 5%.
Means whatever that all tax element is to be borne by you.
Yes, 5%.
That is the to be borne by you.
Yes.
Now, your contract thereupon further got extended. What is the contract for?
Building of roads.
Now, while building the roads, why are you saying that you are not going to get input tax credit?
Because I'll not get every credit. The labor component, the input credit is not there. So when I made the estimate, when I gave a quotation of 50 lakhs, I had in my mind 5% tax component. Because I knew that I had to give a 5% tax component. Now when it changed.
Everything is understood, but the fact that why are you saying that you won't get the input tax credit?
That is the instruction that I have.
No, don't come up with instruction. We are on a point of law. If we are on the question of instruction, then go there before the authorities. If you are on a point of law, only this court will decide. Is it your case on law that you are not going to get input tax credit?
Lordship, then in that matter, the whole BOQ has to be looked into it as to what would be the tax component which I'll get the credit and what
You
I'll
will
not
obviously get the input tax credit. For that, you are buying bitumen. Are you not going to get the input tax credit?
I brought it prior to the GST regime. So how the input will be calculated? If I have brought a, the bills are to be after 2017. They are talking about. If they are levying GST, now whether that GST bill was there or not, that has to be looked into it.
You
Now,
purchased all the bitumen for construction of road prior to the coming into effect of the act.
that instruction I do not have, Lordship. I have to look into it whether.
No, that is the thing. We are concerned. And are you saying that VAT also at that point of time had the inclusive, it is also a value added tax. There also the input credit was there.
Yes, it was at 5%.
If 5% is
Yes, Lordship. That is
input tax credit is an input tax credit. What is there? And have you looked into what is 171?
Lordship, I have not.
Then what is this? You are doing a matter without knowing head or tail about the GST matter. 171 you have to look into. Do you have the GST Act?
No.
And you are starting an argument on the GST matter without an argument. And are you saying that you are going to read it from your mobile?
No.
That day when the matter came up, I told you about 171. Anti-profiteering. Have a look at it. Yes, GST is the main GST.
Easiest.
Huh?
Easiest.
No, whatever maybe, he's also the GST. What has happened out here? There were certain contracts which were entered into prior to the coming into the GST. That was inclusive of taxes. Now, pursuant to that, the conclusion of the contract has happened post GST. Bills were raised post GST. Now, the loss which is being felt by the petitioner is this, that now he will have to pay 13 lakhs, which otherwise was 5 lakhs earlier. Their stand is very clear. They look here. As per section 51 of the GST Act, if the incidence of payment of the bills or the supply work had happened after the GST, then the payment of the payment will be GST.
As far as I remember, some notification is there.
Huh?
There are some notification giving dealing with such type of situation.
That is the notification he is also relying on. And your colleague on the other side have challenged it without knowing head and tail about GST. Yes, what is 171?
Anti-profiting measure.
Read it.
Provisions relating to the anti-profiting measure has been introduced by section.
What? You're reading what?
No, the
No,
section
no,
is-
the section also. Hang on, read your case GST account.
171.
Huh?
170.
I know that, that is what I'm asking him.
Any reduction in the rate of tax on any supply of goods or services or the benefit of input tax credit shall be passed on to the recipient by way of compensatory reduction in prices. The central government may, on recommendation of the council, by notification constitute an authority or empower an existing authority.
So what is their thing? Any loss or any gain, a person can't profit on the basis of the tax. Because here, the moment you are going to take a particular amount, you are buying just, for example, bitumen, there will be an input tax credit you will be taking. There will be an output tax by him who is selling the bitumen to you. And that output tax, you will claim it as your input tax and put it in your register, electronic register. Isn't it? And then when you get that, you can claim it. And with that, you can also make the payment also. Your tax. Now, in that process, if the amount goes more than what you actually ought to have got. Just for example, there might be a certain cases where you were just entitled to this 5 lakhs. Or this is the amount. But with this output tax credit, because now what is happening? The central excise also comes within it. Earlier, the central excise, there was no concept of input tax credit. Now you have the excise duty which is being paid out there will also be an excise input tax credit.
That is now.
Yes. So the moment the excise duty is there, which he will show it as an output tax, he will claim it as an input tax. Because of that, the amount will go up. Now, these 13 lakhs which you have to pay, can use it with your input tax credit, which you have earned, and pay it to the electronic ledger. And if it is more, whatever happens out there, if the amount goes more, then in that case, you can't get the benefit. That is what it is.
But see, in railway matter, probably similar type of issues were decided by your lordship.
That judgment I have given him, I have told him to read what is input tax credit. You are not reading it, and you come without the GST. Have I explained how it works? You have to know how the GST works. It doesn't work like this. You see, you are saying about input tax credit. You are just saying about VAT. But you don't know that VAT also contains the input tax credit.
Yes, it is there.
It was already there. Input tax credit. So you can't say that no, now I can't claim and all. That input tax credit was already there in VAT also.
Lordship, the input tax credit in VAT would have been limited to 5 lakhs. Now, in the VAT regime, now that's what I factually were in the construction of this road. Now, in the VAT regime, what were the input tax which would be payable, and the GST, what will be the difference? Because as per the petition and which has been written out here, that they in labor and other sectors they are not getting the input credit. So what I pray, Lordship, is that I'm in just 1 week time, so I can I can sit with the client and detail out the point as to what will be the difference part, as to what input credit do I will not
Because
be getting.
earlier, you never got the input tax credit on the excise duty paid on the bitumen. Now you are going to get it. Because that will be shown as the output tax by the purchase seller.
But the bill which I'll be raising, whether it will include that component.
See, you are to pay some tax. The GST you are to pay. How do you pay? There are two ways. One is a cash register by which you directly pay. Not, however, I'm not saying with physical money, but you pay from your own pocket. And the other is the electronic register. This electronic register is based upon whatever input tax you gather in purchasing something where the other person shows as the output tax. So this amount which will be credited to your input tax, provided you have made the application for claiming within a period of 120 days or something.
My bills are at the time when the circular was issued and when this transition was over. Half the bills were paid off VAT, half was GST. So when I was working, when I raised the bill of the same work, half was of VAT. So regarding the next portion, when after 2007, because the circular contemplates two positions. One is prior to 2017, the particular case.
Prior to that statement, they will say that we are going to deduct there.
That is
But
deducted and that
here,
is paid off.
what has happened as per the GST Act, they are saying is look here, the supply has happened now. The bills have been raised now. So under such circumstances, the deduction of tax, the supply of goods or supply or service has happened now. So under such the GST has to be deducted. If your supply of goods would have been done prior to that, then the question would have been given under the VAT Act. So what is wrong out there?
In fact, in my case, the bill that has been raised, I had given the deduction of VAT. They have given me the whole amount. In fact, it is I who went and said that deducting VAT amount. They have not deducted any GST or VAT in my case.
And Mr. Das, another very important aspect. Your business was to do it inclusive of taxes. If it is inclusive of taxes, you are to bear the burden. Are you not going to bear the entire thing? Whether the profit goes or here or this way, that might be a question that the GST Act may be bad. But why will they not deduct it? It's all inclusive of taxes. Unless you challenge the provisions of the GST. Yes. There's no other way out. You never thought about the GST coming into force. And as such, you quoted in a particular manner. Now a loss has happened because of the GST Act coming in. They are going as per the Act, saying that look here, some goods, supply and service has happened now. And as such, 51 applies and we are going to deduct. So they have done it rightly. So what is wrong with them? Yes, a loss must have happened to you, but that is a different thing, and that is because of the Act.
That aspect,
What does your learned colleague from the other side say nearby? What do they? Ah. You wanted to do this matter. You read that judgment. There you will understand. Or the judgment of another judgment of Liberty Shoes of Justice Chandrachud. Read that. Read both the judgments. You'll understand what is the concept of GST. Then only you can do. You are doing a GST matter without knowing head or tail what to do. By this time, I could have disposed of some matters. That is one for making you understand. Yes. When? After puja. Better. Huh? Will take some time for you to. At the request of the learned counsels for the party, for the petitioner, matter stands adjourned to be listed again on 21st of November 2023.
Much appreciated.
Liberty is given to the petitioners to reply to the affidavit so filed by the learned counsel appearing on behalf of the state respondents. The state finance and taxation department is further directed to serve additional copies of the affidavit in opposition to the other writ petition.
I will listen.
Everybody got it?
Everyone.
Okay. The petitioners are given the liberty to file their reply to the affidavit in opposition by the finance and taxation.
I was directed to file affidavit as to whether the subsequent challans were deposited by the petitioner and whether they were related to the case in present issue. But since the challans were of 2013 and 15, it requires some more time, right? Receive a communication from the department. They could not find out.
No, I have given some directions here.
Yes,
Taking into account the above and the challans which forms a part of the additional affidavit filed by the petitioner on so and so. This court directs the joint commissioner to examine as to whether the challans enclosed therewith as annexure are in respect to the pending litigation, the reference of which have been made in the form and file an affidavit in that regard.
There are 4 challans, 2 of 2013 and 2 of 2015. Since they are all lost, they could not find out, so we require some more time to set any whether it is available. And interestingly, lots it.
Yes. Okay, you file your affidavit. How much time?
What's 4 weeks?
This court by the order dated 10/8 by the detailed order dated 10/8/2023 had directed the Joint Commission of CGST to examine whether the challans enclosed to annexure A as annexure A to the additional affidavit are in respect to pending litigation, the reference of which was made in the form number SVLDRS-1 and to file an affidavit in that regard, comma. Mr. S.C. Kyle, the learned counsel, standing counsel of the GST, submits that as the said challans are very old payments, some more time would be required for making those verifications and seeks an accommodation of 4 weeks. Taking into account the above, this court fixes this matter again on 3rd of October. The affidavit as directed by this court on 10/8/2023 be filed by 29th of September.
RT,
Yes.
In pursuance of the last order method, the registry has already placed the order of the honorable Supreme Court dated 5th of September 2018. Elashe Madrid.
This is for rape victim. This scheme is for what?
Initially, method it was method expected to be rape victim, method substitute other victim also included.
Other means
Other means method.
all women.
All women.
So what does it say? This scheme has been approved by the Supreme Court.
Yes.
How does a person get it? There shall be a fund, namely the woman victim compensation fund, from which the amount of compensation as decided by the state legal service of the year shall be paid to the woman victim or her dependent who have suffered loss as a result of an offense. And Now what happened?
And in our case, my lord,
Who are you?
I am the father of the victim.
How are you entitled to?
My lord, the father is also included as dependent, my lord.
No. First you have to be dependent.
Victim, my lord.
How are you dependent?
My lord, not dependent, my lord, as victim, my lord.
Huh?
My lord, section 2WA of the CRPC as well as the, my lord.
No. As per this scheme, who is entitled?
Yes. My lord, in our state scheme, my lord.
Dependent include husband, father, mother, unmarried daughter, minor, so and so, on the basis of which a report to the subdivisional magistrate as determined by the state legal services authority or so and so on the basis of the report of the subdivisional magistrate of the concerned station officer investigator or on the basis of material placed on record by the dependent by way of an affidavit or on its own. A woman victim or her dependent, as the case may be, shall be eligible for grant of compensation from multiple schemes available to her. However, the compensation received by her in other schemes with regard to section 370-57B shall be taken into account while deciding the quantum in such subsequent compensation application. So, if you have received in some other application, here you won't get it.
They are also entitled.
No.
Entitled, my lord.
Shall be taken into consider while deciding the quantum.
Quanta, yes. They are not,
So they may be less also.
maybe less, yes.
You may not be entitled to what has been otherwise stated.
Yes.
It has to be taken into account that if you are getting some other benefit, just for example, in another case where you are getting the benefit under that 15/11/2014,
Yeah.
or even under the Assam Victims Compensation Scheme 2012,
Yeah.
if you are getting that 5 lakhs on account of death, then are you going to get the same 5 lakhs here?
Yes, my lord. I plan there.
How?
My lord, come to page 62 the input order.
No.
The-
In the scheme.
In the scheme, my lord, as per 12 scheme, my lord, I am entitled 5 lakh.
Huh?
5 lakh.
Where?
My lord, notification at page 24. Page 24.
Victim.
Victim
What
compensation,
happened to the victim?
my lord. The definition of victim, my lord, page 20.
Oh.
2F.
Page 28 of what?
The notification dated 18 of October 2012. Victim means definition of victim, my lord.
Where?
F, my lord, 2F.
2F is central fund.
State, this is a for state fund. This is notification issued by the state government.
Where?
2012.
Page?
18 October 2012.
Page.
Page 20, my lord.
This is the victim's compensation.
Yes, my lord.
You are asking under which one? Nalsa or this?
Yes, my lord. As per NALSA also entitled, my lord, but the PLSA has already provided only 1 lakh rupees. The improved order at page 62. As per victim compensation scheme of our state, the petitioner entitled 5 lakh. And if the compensation is given under NALSA notification, my lord, then 5 to 10 lakh. But the TLSA already given 1 lakh rupees. My lord, page 62.
That is okay. There you may get it. I'm not on that. But here the larger question is, where are you applying?
I have applied under a state scheme, my lord. My lord, are representation at page 59. Page 59.
You are applying under the Nalsa scheme.
No, my lord. Under the state victim compensation.
No. See your prayer.
Page 59, my lord.
Prayer at page 17.
In terms of the compensation and the government of Assam notification dated 1/2/2009. Is the page 20.
So what is the amount you are asking?
My lord,
You are asking 10 lakhs on what basis?
my lord,
And why is the husband doing it? My father doing it? What
that is
happened to the crime? Let us see the crime.
302, my lord.
Yeah? What 302?
Murder, my lord.
Murder for what? How did the murder happen?
Page 40, my lord, the judgment test. Page 41,
Rape.
rape. No, my lord, murder. Only murder, my lord.
Why is 376 used?
Not
You have not read it properly. Annexure 4, C, omitted by so and so. The learned SDGM Bilasipara in DR in number area under section 143, 376.
Allot page 56. Accused Sattar Ali found guilty under section 302. Page 53. Under 302, my lord.
But why is the father asking the money?
Because, my lord, father is entitled, my lord, as per his scheme, my lord.
Huh?
As per his scheme, my lord, the father entitled.
No, no.
Yes, my lord.
The dependents has to show that they have suffered some loss on account of the death. Kindly see that scheme also of 2012. Let us see that. Why it
My
will
lord,
be
page 20.
eligibility. Kindly see page 21.
Before page 20, my lord.
Page 21.
My lord, the
Page
15.
21.
Yes, my lord.
The victim or his dependent satisfying the following criterion shall be eligible for grant of compensation. Loss or injury sustained by the victim. That is okay.
Yes.
Or his dependent should be have caused substantial loss to the income of the family, making it difficult to meet their both ends without financial aid, or has spent beyond his means on medical treatment of on mental, physical injury, and a recommendation is made by the court for compensation, which is not there.
Okay.
The victim of the dependent reports the crime to the officer in charge of the police station or the judicial magistrate of the promptly, provided the district is satisfied for the reasons to be recorded in writing, may condone the delay in reporting. The victim cooperates with these are okay, not there. But there has to be some loss caused to you.
But, my lord, before that, my lord, page 20.
Page 20 says what?
2F, my lord. 15.
Yes.
Who is the victim? Victim means a person who has suffered any loss or injury caused by reason of the act or omission for which the accused person has been charged. And the expression victim includes his or her her guardian or legal heir.
Absolutely.
And I am
Now
the legal heir.
does this woman
Yes.
who died had any children?
No. There is no any difference.
You know, how is the father entitled to? This is a very difficult thing to understand.
But as per definition, my lord, legal heir.
No.
Legal heir. Yes.
How can the father be a legal heir?
Yes, my lord. After death of my lord,
How can the father be a legal heir? Tell me.
my lord, the legal heir certificate also issued by the
No. Let them issue whatever it may be. Tell me, she's a Muslim.
yes.
In a Muslim, the father becomes the legal heir of a woman.
My lord. When there is no any issue, my lord, then father and mother.
Mother is a different thing, but I'm asking about the father of a married woman. Would he become a legal heir?
In absence of any son and
Don't
daughter.
make this type of submissions out there without knowing.
And mother also there, my lord.
Mother is maybe different,
Mother also there.
but mother is not the petitioner. And it is dependent upon the loss.
Yes.
It's dependent upon the loss. You see, this NALSA scheme which is being given. Kindly see, here also NALSA, kindly come to page 31. See the eligibility, how a person will get. Injury, see, eligibility for compensation. Procedure, page. Relief payment. The AIA may award compensation to the victim or her dependents to the extent as specified in the schedule attached here too. Factors to be considered while deciding the matter, the state legal services may take into consideration the following factors relating to the loss or injury suffered by the victim: gravity of the offense, severity of mental or physical harm or injury caused by the victim, suffered by the victim,
Gravity of
expenditure incurred, loss of educational property, loss of employment, relationship of the victim to the offender, if any, whether the abuse was single isolated incident, whether the victim became pregnant, whether the victim contracted so-and-so, whether the victim contracted human so-and-so, any disability suffered by the victim, financial so-and-so, in case of death, the age of the deceased, her monthly income, number of dependents, life expectancy, future promotion, growth prospects, etc., or any other factors which so-and-so may consider sufficient. Procedure. 9. Where a recommendation is made by the court for compensation under so-and-so, or an application is made to the so-and-so, provided that in deserving cases in all exceeded tax or any commission of any offense, may sumoto give it.
my lord, factors, my lord.
What factors?
Factors.
Factors I've read it.
Expenditure incurred or likely to be incurred on the medical treatment for physical and or mental health, including counseling of the victim.
Here the expenditure does not arise because the death has occurred, then you went out there to see.
Then investigation, inquiry, trial, other than right.
Then
Yes, my lord. 2. Investigation, inquiry, or trial also included.
because she is married, that is a different thing.
But we have, my lord, filed the criminal case, and we have cooperated during the investigation as well as in
You filed the criminal case.
FIR lost by us, my lord.
Who lost?
Yes, my lord. One of the cousin of the victim, my lord.
Then what did you do?
And we have also cooperated in the trial, my lord.
You were a witness. Let us see.
No, father is not a witness.
Then,
Father is not a witness.
you're not a witness out here.
But other are witness. my lord.
Huh?
Cousins and others are witnesses.
Then why the cousins should not get it?
Since
Why you should get it? Tell me. I'm not on others. Yes, the schemes are okay, proper, but why should you get it? What is the loss which has occurred in you? You have given the daughter in marriage.
Yes.
Why is the father impact? Why not the mother?
Father also there, my lord. My lord kindly come to place 59 months. There we have stated, my lord.
Hmm. Yes. It has been given by the father. I am the legal heir of late
Last-
Quinton heir. The notification also includes the legal victim heirs as victim that deceased so and so left behind me,
My lord,
and
last three
my
line, my lord.
aged mother as legal heirs. Now we are suffering from mental agony in absence of my daughter. We have no other source of income source, and I am aged so and my own wildlife. My wife is aged about 70 years.
Yes, my lord.
So here, this person has approached you for filing this application. Because all your other applications have the same wordings.
My lord, get 60, my lord,
Huh?
60 on the next of kin certificate, my lord.
Yes, Mr. Talukdar. Tell me.
Well, there are so many other things, man. They have to produce the dependency certificate and other things are also there. But um, whether father was dependent, that will be. And what has been given is under 357 plan also.
No, why 1 lakh has been given?
What is the basis of the?
No,
the
because
awarding
here
1
the
lakh?
problem which arises is this.
Hmm.
Kindly come to this scheme. Forget about the Nalsa scheme.
12 scheme, man.
In
2012.
your scheme,
2012.
yeah, the minimum on account of it's a death, it's 5 lakhs. Page 24.
5 lakh.
Then why not 5 lakhs?
Whether under this scheme it was given or the other.
This is the scheme under which they have given. If you say about the other scheme,
That will remove. But it has to be the amount already given has to be set off properly. My lord, therefore probably your lordship wanted to have a look at the record. I call for the record.
no, I am not concerned. Records are not necessary. We are not concerned with the record. Here is a case, simple case. Normally I would have granted. There is no problem with that. But you see, giving it to the father, what was the age of the victim
My lord,
when he died? When she died?
immediately after 4 months of marriage. Immediately after 4 months of marriage.
And when did the incident happen? 2003.
2003. 25/3/2003. Five, 6 months ago. The incident occurred, my lord, after 5, 6 months of marriage.
No, but one thing, at that time when it happened, there was no victims compensation scheme. Then under what circumstances you are going to get now?
But the judgment is passed in the year 2016, 18 matter.
So then,
And there is no any limitation or there is no any effect was given in 357A.
now what do you say about limitation at number 7, page 22?
This limitation is not applicable in this case.
Why?
Because the trial has commenced, my lord, and the accused is convicted, my lord.
So
This
what?
provision is applicable only in respect of 357 for A4, my lord. Where, my lord, the offender is not traced or identified, but the victim is identified. And where no trial takes place, the victim or his defendant may make an
Yeah,
application.
Hmm?
This is applicable only for 357A4, my lord.
No claim made by the victim or his dependent under subsection 4 of section mark shall be entertained.
And our petition, my lord, under section
357A,
2 and 3. 357, 2 and 3.
where the offender is not placed or identified, but the victim is identified. And when the trial takes place, the victim or the victim and the victim. Right. So 7 would not come in.
Yes. That part, my lord, section 357A, there is no any limitation.
Hmm?
There is no any limitation. Right, under section 357A. And
In coordination with the central government, shall prepare a scheme for providing funds for the purpose of compensation to the victim or his dependent who suffered loss and injury. Now kindly come to page 24.
just
Last but one line. This supersedes the earlier schedule of Assam Victim Compensation Scheme 2012 and shall be effective from the date of issue of this notification. Meaning thereby, as on the date on which your application was filed.
our application filed on, my lord,
8/4/2019.
2019.
No, your judgment was passed on 18/7/2018.
18. But there was no any recommendation, madam. There was no any recommendation on.
So if you make it after another 5-6 years, another new scheme comes in, you'll be entitled to that.
My lord. In this figure, my lord, date of birth.
Because the incident happened in 2003.
Yeah.
Trial finished in 2018. Then you did not file then. You filed in 2019. After the
Right.
coming into effect of the new.
But in this notification, my lord, although it is superseded the 2012, my lord,
Hmm.
but it is not stated, my lord, whether the earlier case was considered under the old notification. It is not stated, but that is why, my lord, our case is open, my lord, in the new.
Which is otherwise there in the 1511.
Yes.
The instant repetition has been filed challenging the order dated 22/1/2020 passed by the Secretary District Legal Services Authority Degree, whereby the petitioner was awarded an amount of ₹1 lakh by the Secretary District Legal Services Authority. The facts involved in the instant case is that the daughter of the petitioner, one Sahitun Nessa, since deceased, was killed
Murdered by her husband. 125 3,000.
was killed on 24/3/2003 and an FIR was filed by one Malbar Hussain on 25/3/2003. On the basis of the said FIR, a Bagribari police case number 31/03 was registered under section 147/311/511/302 of the Indian Penal Code. Pursuant to the investigation carried out, charge sheet was submitted against the husband of the petitioner's daughter, One, Mr. Sattar Ali. Pursuant to the charge sheet being filed, a sessions case number 26/2008 was registered under section 302 of the Indian Penal Code. By the judgment dated 18/7/2018, the charged accused, Mr. Sattar Ali, was convicted under section 302 of the Indian Penal Code and was sentenced to undergo rigorous life imprisonment and to pay a fine of rupees 15,000, and in default, 6 months rigorous imprisonment under 302 of the Indian Penal Code. Subsequent thereto, the father of the petitioner filed an application to the Secretary District Legal Services Authority Hubli on 8/4/2019, seeking victim compensation in terms with the Assam Victim Compensation Scheme 2012. A perusal of the said application, which have been enclosed as an excerpt 5 to the writ petition, shows that an amount of rupees 5 lakh was sought as compensation in terms with the notification dated 18/10/2012 and 1/2/2019, read with the provisions of section 357A of the Code of Criminal Procedure 1973. Pursuant to the said application, the Secretary District Legal Services Authority Hubli passed an order on 22/1/2020, whereby an amount of rupees 1 lakh was awarded in favor of the petitioner, which was directed to be paid subject to availability of the fund. This order dated 22/1/2020 has been assailed in the instant writ proceedings. This court have duly perused the notification dated 18/10/2012 and the notification dated 1/2/2019. The same notification dated 18/10/2012 do not prescribe any limitation for filing an application, save and except a case falling within the ambit of section 357A(4) of the Code of Criminal Procedure 1973. Further to that, clause 5, class 4 and 5 of the said notification dated 18/10/2012 stipulates the eligibility for compensation as well as the procedure for grant of compensation. The schedule to the notification dated 18/10/2012 stipulates the maximum limit of compensation for rehabilitation in case of death at ₹2 lakhs. Interesting to note that the said schedule did not stipulate a minimum limit of compensation. However, by the subsequent notification dated 1/2/2019, the minimum as well as the maximum compensation have been mentioned. In clause 9, at serial number 9 of the said notification, in case of death, the minimum as well as the maximum compensation have been stipulated at ₹5 lakhs. However, surprisingly, the District Legal Services Authority, by the impugned order dated 22/1/2020, only granted 1 lakh for reasons best known. Under such circumstances, this court therefore interferes with the order dated 22/1/2020 and directs the District Legal Services Authority, Dhubri, to pass an award within 2 months from the date a certified copy of the instant order is served upon the Secretary, District Legal Services Authority. An award in terms with the notification dated 1/2/2019. Taking into account that the maximum and the minimum amount of compensation is ₹5 lakhs, nothing further requires to be adjudicated, and the District Legal Services Authority, Dhubri, is only required to pass the award. Upon passing of the award, this court further, by the District Legal Services Authority, this court further directs the Secretary of the District Legal Services Authority, Dhubri, to forward the same to the Commissioner and Secretary, Health, Home and Political Department of the Government of Assam, who Potwit. The Commissioner and Secretary, Government of Assam, Home and Political Department, shall, upon receipt of the award, within 2 months therefrom, disburse the amount to the District Legal Services Authority, Dhubri, so that the said amount could be disbursed to the petitioner. within 15 days thereafter. With the above observations and directions, the instant petition stands disposed of. This court further directs the petitioner to serve certified copy of the instant order upon the District Legal Services Authority, Dhubri, upon the Secretary, District Dhubri, as well as also to the Commissioner and Secretary, Government of Assam, whole Home and Political Department for necessary compliance. I've not gone much into that. The reason is I have some doubt as regards how.
Dependable.
There's a very serious connotation what is happening. In fact, this needs to be clarified. And why you are having minimum and maximum to be same? You see, while making the scheme, you gave a discretion, thereby fixing a maximum. And in between, there's a discretion. But while making the notification subsequently, you did not do so. So under such circumstances, they have not.
They have no other option. They have to either.
That's okay. Now, as per your notification of 15/11/2014,
That is,
category they mentioned.
that is probably accidental.
Accident also, death also. You categorically mentioned that, look here, this amount would be, have to be paid.
Depending on
And
the
on or before the accident or anything incident must have happened on or before so and so. But what is going to happen is it will open a Pandora's box. 1950 also, somebody dies out of an accident, he may file. You're not having anything, do something. If I'm giving it, but you land in problem, and because with this judgment, Mr. Hussain is going to come with another 25 years.
31.
Right.
Lordship, this matter is looking to get special
Oh,
rate.
you got it?
Lordship, here I have received instruction, if the department didn't find any application paying for special rate in this case.
Huh?
The department didn't find out any application submitted by the petitioner. And I check up the Lordship may come to page 186.
Oh, same like that one.
Yes, Lord. There were two units. In another unit, Lordship, we are receiving application, Lordship.
183.
Page 186, Lordship.
Yeah.
Only auditor's report is there. And I've checked up the statement. There is no clear cut statement when they submitted application.
There's no application enclosed.
Lots. This is
Oh.
only auditor's report. They have stated in their index. Lordship,
Yes, madam. Huh?
Lordship in
Eh,
index,
bad day for you. Huh?
they have stated that annexes.
Yes, let them file an affidavit.
Lordship,
I fixed that the other one on 13. Huh?
Lordship. Yes.
Similar issue.
Yes, sir.
Madam, you file an affidavit bringing on record whether you have filed an application because you are enjoying a stay. And have got a similar order
Yes, similar order.
and not to act upon the aforesaid demand till a decision is taken by the respondent authority regarding fixation. As of now also there is no application.
For the petitioner, Lordship, there is no application. And in the writ petition also, they have not annexed any such type of application.
When the matter was taken up today, the learned counsel, standing counsel for the GST, Mr. S.C. Kayan, submits on instruction. That the petitioner herein had not submitted any representation till date. for fixation of the special rate in terms with the notification number 20/2007 dated 27 dated
25/4/2007.
25/4/2007. If it is submitted. Then an entire perusal of the entire petition also would not show that any representation to that effect have been included or made a part of the petition. The learned standing counsel further submits that on the basis of false averments being made, they filed the representation.
Yes, Doctor.
An interim order is operating against the revenue since 8/6/2021, for which the instant repetition should be dismissed. This court duly takes note of the said submission, but is of the opinion but taking into account the submission of Ms. H. Jane, the learned counsel for the petitioner who submits that she has no instructions in that aspect, fixes this matter again on 13, when did I fix? 13th of September 2023. The petitioner is directed to file an affidavit bringing as to whether any representations have been filed, and if so, bringing on record those representations, showing that the said representations have been duly received, showing and indicating therein when the said representations have been duly received by the
GST department.
GST. District. What type of cases you are filing? Two matters is happening in this manner.
Thirty-two and 33.
This matter also regarding this fixing of a special rate is relating to delivered. On last occasion, I submitted a written instruction that their case is being disposed of, but that was not correct. That was relating to some other case. And in this case, Lordship,
You have not fixed till now.
yeah, Lordship, it is fixed on 18th September for personal hearing of the petitioner, Lordship. The case is fixed on before the commissioner, Dibrugarh, on 18th of September, asking the petitioner to present along with the document. That notice has been issued to them.
So we fix it on 3rd of October.
Lordship.
3rd of October, get the order.
Yes,
Both the matters.
yes, both matters.
Actually, my lord, 20th September is the fixed for hearing by the committee.
Anyway, whatever orders are passed it.
Yes,
So that
at that time, Lordship, it will be.
Mr. S.C. Kyle, the learned counsel appearing on behalf of the petitioner, respondent appearing on behalf of the GST department, submits that inadvertently it was mentioned on the last occasion that orders have been passed regarding fixation of special rate in the case of the petitioner. He, however, submits that 29/2023 is the date fixed where the petitioner will have been directed to produce the necessary documents so that the fixation, so that the applications regarding fixation of special rates could be considered by the
Commissioner, Dibrugarh.
commissioner
Commissioner GST Dibrugarh.
Commissioner, Principal Commissioner,
No, see Commissioner,
Commissioner, Dibrugarh,
not,
GST Dibrugarh, CGST Dibrugarh.
not.
This is the matter again on 5th of October. The Learned Council. The Learned Council for the petition, the Learned Councils appearing on behalf of the parties are directed to apprise this court as to whether any further, as to whether, as regards the result, as regards the outcome of the hearing to be conducted on 29/2023 on the next,
Yes, much.
and produce any orders if so passed. Get this thing done, unnecessary these matters. Interim order is there until further orders. There's no interim order.
I have not.
Notice is never issued that they have not filed any, there is no interim order till date, but they have not taken any court action.
No interim order. You are the one
not.
not getting an interim. There are others who are getting interim.
34 to 36.
Please to produce the order dated 25th of July 23, by which my learned friend was requested to obtain his
Mr. Espora returning submitted a due to demolition and shifting of the office of the GMC from its earlier location. The original records could not be traced up till date despite the fact he had stayed for 3 weeks time the last one. Yes,
I could trace, ultimately, we could trace out 2 files, my lord.
Huh?
Ultimately, we could trace out 2 files, my lord. I didn't get time to go through the files, my lord. The two
what is
files
this? Matter is
are
pertaining to what?
PSUP's house, my lord.
Huh?
Allotment of house.
allotment houses to the
Houses.
sweepers of the GF.
Allotment of?
The house
Houses,
under
ma'am.
the JNU are.
And why are 3 writ petitions?
Different petitions.
Then in one petition, why we are having so many petitioners?
Yes,
Have you paid the court fee?
common.
What is the common cause of action?
That their flats were allotted lordship, which were cancelled without issuing any notices, without hearing.
Or like nature should not be issued for setting aside and quashing the impugned rejection order dated 21/9/2000 Iman being so and so by the respondent number 5. The commissioner and to keep possession of the dwelling unit quarters constructed in Zone A at Kakasil GMC horizontally under the scheme under the Jawaharlal Nehru National Urban Renewal Mission as per the building wise. Now, where is that order? Let us see 21/9/2012. Yes, got it.
This
Is this type of
will
order?
take time, Lord.
Mr. Roy, this doesn't take time. This type of matters doesn't take time. Where objections are received from the public regarding non-allotment of 72 PPCs Yes, Mr. Roy, why are you challenging this? You have not been given.
No, but it's to some of the petitioners, the flats were allotted. They had deposited the amount.
The 5,000.
Yes, thereafter it was abruptly cancelled without issuing any proper notice.
Which was cancelled?
Page lordship 54.
Huh?
Page 54.
58.
Cancel, so and so has been allotted. Cancel. No, so and so has been allotted. Page 59. What is this type of allotment?
His lordship, the central government under the scheme of JNURM has provided the fund to the state government law for the construction of the collecting the flag to the urban poor. And entire finance was given by central government. Thereafter, the DMC was appointed as the nodal agency to implement the scheme. Accordingly, lordship, the petitioners were and other petitioners also in the red petition lordship, they were allotted the flag.
In terms with 21.9.
Yes.
You were asked to deposit this 5,000.
Yes, we have deposited.
And then they cancelled it.
Cancel.
Why?
Cancel lordship. Lordship may
Where are your numbers? Petitioner number 2.
number 5.
Late Tataram. Name of the beneficiary, KDB, daughter of so-and-so. Cancel as Allotee Tataram died. A. Lakshmi, daughter of so-and-so and sister of so-and-so have been allotted B4S6 as serial number 158 of the list of so-and-so. Meaning that right? What do you mean by this? That means,
Cancel
are you allotting, have this person been allotted some other accommodation?
These are they were allotted, but subsequently we found that there is a committee, they found out that there have been one or other defect. Remarks have been given from page number 58 in the right hand column.
Yeah, it
What
says
is-
cancel.
Cancel.
As Allotee Tataram died. Very well.
Cancel proof of earlier Assam type water within the potential area is seen and therefore cancelled.
Where?
In page number
No,
58.
no. We are concerned with serial number 9, Tataram.
Yeah.
Is
Cancel.
petitioner number 2.
Yes, yes. Cancel. As
Here it
allotted.
says
Tataram died.
allotment certificate is given. Cancel. As Allotee Tataram died. A. Lakshmi, daughter of late Tataram and sister of late K. Kameshwar Rao, has been allotted B4S6 as serial number 158 of 269. What is this 158? Huh? What is this concept of that?
Allotted B.
This is a matter of 2012, Mr. Bora. You
Yes,
should be knowing it.
There is a list, my lord, that 158, it first says that 150, the B4S6
So
have been
I
accepted.
have you cancelled it because she has been given some other land?
Other they only have to get only one.
Obviously, they can't have two.
Two.
There's
They
no
are
question.
separate.
There's no that is not the foundation. This is only for homeless people.
Yes.
A person who has no home or anything out there, they don't have. So this is only given to those homeless people. Now, if a person is given another, it is there. But what do you mean by this?
Cancel and allotted Tataram died.
Hmm.
K. Lakshmi, daughter of late Tataram and sister of it. K. Kameshwar Rao.
Just for
Has
example,
been
see number 10. So and so, wife of so and so. Name of the second beneficiary, M so and so. Cancel. Son 1, Aparao has been allotted dwelling unit number so and so at serial number 257 of 269 list. What is this 257 of? Because
So
there
there
is
is
some list of 269 persons.
There is a list of 269 persons, Manoj.
Ah.
Start from page number 34.
Page
34.
34.
34.
This is what? 34. Building wise allotment of house number in Pati. Now let us see this petitioner number 2, serial number 9, 158. Yes. Then goes by this 158 A Lakshmi. Then 257. Yes. Here is yes. From Apparao has been allotted dwelling unit number B9FS. B9? These are B7? B9. No, this is 352. Where is that list of 269? And Mr. Roy, what is all these are type copy? These allotment orders are different. Annexure 8, all are different. Here there is no signature on. How is it
It
possible?
is copy of the allotment order dated 12.
Kindly come to page 76 of the disposition, Mr. Bora. You have filed an affidavit.
Yes, I will make it a
Yes, you must have paid. Yes. Mr. Roy, have you given the position?
After allotment lordship, abruptly they cancel it. And position has
And what is the ground on which you are assailing? Principles of natural justice?
natural justice lordship, allotment order to issued all, I have annexed lordship.
No, that is okay, but
Thereafter lordship.
your cancellation, you are challenging on the ground of natural justice.
Apart from that, lordship, there is an order to direction to my learned friend to furnish the number of the vacant flats available. But I till date,
No, there are 33 petitions, till date, 33 petitions, all the three petitions for total, 33 places are still vacant, they're keeping it vacant. So because of some untoward incident,
Huh?
because of an fire, untoward incident of fire, those people from 33 flats have been given to 33 persons, they're occupying it on a temporary basis, subject to outcome of this.
They are occupying it on temporary basis.
Temporary basis, subject to outcome of this. Their undertaking has been taken.
So the moment I allow this petition, you
They will
will
have
vacate
to,
them.
right, they'll have to. Okay.
You'll hand it over.
lordship, what happened in 2023, about 5 months back, fire broke out in the Harijan colony.
I broke out over there.
I
Yes,
did.
that I read it.
Lot. And this writ petition is pending since 2030.
Yes.
They were not
You are
providing
only
it.
saying that to delay the matter further. You are only saying that this matter will take some time.
No, this matter-
But the only thing is you need a resolution as fast as possible.
Pardon me.
Now, did you give a hearing to them? The problem is you are not being able to trace out your records.
The record has been traced out, my lord, but I have not gone through the record.
No, no.
with them.
I don't understand what do you mean by these orders? And you are the affidavit filed by the commissioner is not clear on that aspect.
That I have.
That why you are cancelling these people saying that allotted in some other place, meaning are they allotted in some other building?
No, no, no.
Meaning there are some, all are different, causes are different. All has a different.
That you have said it, for which Mr. Roy is going to pay the additional court fee. That's a different thing.
No, not my lord. Remarks for not allotting. In the right hand column, all have a different reasons for rejecting, for cancelling, whatever they are.
No,
All-
that is why, but whatever may be, everybody has come together. Only thing is that everybody has come on the ground of natural justice. Anything else, nothing more. Your case is that you have been
Yes,
issued an allotment letter, but that has been cancelled without giving you an opportunity of hearing. That's all. What is there to decide further?
Rules are already
Like
kept
this,
there.
then you decide giving them each an opportunity of hearing. What is
That
there
can be
to
done.
do? Isn't it? That is
That
the only go-go situation to save Mr. Roy with additional burden of paying court fee.
They are secret lordship. There is a common code. In case of common.
How can there be a common cause? Tell me, how can there be? Everybody has been issued a separate allotment letter.
Lordship, but all are victims due to cancellation of the allotment order, same impugned order.
Oh.
Lordship, please, same impugned order.
So, where is the
For
impugned
all
order?
the petitioners,
No,
lordship,
show me, where is the impugned order?
page 54. Common order, Lord. That's why I have filed the,
Page 54? Page 54 is the allotment order.
It is
no, page, impugned order is
56.
lordship. Page 54, yes.
Page 54 is not a, it is an allotment
No,
order.
that is the impugned order.
21.
It starts from lordship page 50, annexed 3, page 54.
54 or 56.
Hmm?
Following instruction appended here to office. No, this is the direction that you pay 5,000 rupees, you get it. That is the direction. You are challenging 21.9 or 21.11. What is the order you are challenging?
Sorry,
21.9.
No, your lordship is that 50,
56.
page
Page 56.
6.
Matter for 23. And these are the 28 here.
Here in the present petition, Lordship, there are
But are these 28 not against individual allotments?
in the allotments are different, but
So then,
impugned order is common.
so what? Are you not affected?
No,
Individuals are not affected.
affected Lordship because the
But are you telling me that there is only one common allotment order? What has been assailed, what has been struck out is all the allotment.
need Lordship, I will pay the court.
Eh,
But
it is better.
take into
So
consideration,
that
Lordship,
stand
the
was taken in the.
little man of the
That stand
society.
was taken in the affidavit. All have a.
Yes, I've seen it.
No, deficit could be paid in that day.
No, I am asking you, you have to pay the deficit. I think
They are the little men of the society.
Eh?
They are the little men of the society living in a plastic temporary state slum.
So for that, Mr. Roy will spend it from his huge resources. Huh? You do something, do some, what you call, public. You see, the only way out here is, this is not clear, the reasons. And they have not been given an opportunity. Although, one thing is reflected out here. Therefore, decision on the matter for allotment of ER in the pending so and so. And so and so will discuss the undersigned hereby notified. Whereas objections were received from the public regarding non-allotment of houses, and whereas there has been an incident at the temporary state where 16 families are sworn to streamline the beneficiary list of sworn. It doesn't also have reasons except the reasons which have been mentioned out here.
Yes.
And these reasons which we are mentioning out here is not being supported by anything in your affidavit.
Let them get a personal hearing, each and every individual, then since we
I
are.
think that is the base.
Yes.
Because this road can't pass an order of allotment.
And that's why this.
An
because of this-
allotment order has to be
These
passed.
cases, 3 cases involving 33%, we have kept 33.
And then you take a call within that thing. I think that is a win-win, Mr.
Lordship, GMC is only a Lordship, may please to consider, GMC only a nodal agency, just to implement the JNE for the basic services or urban people lot. Actually, the GMC Lordship does not have any power once the flats are allotted to allotment order is issued.
Allotment is issued by whom?
Allotment order is issued by the GMC. But they are GMC is the only loading agency, nodal agency Lordship to implement the scheme.
No, understood.
I have annexed the annex to
Understood.
Lordship.
If the person who has the power to allot wouldn't have the power to recall,
Recall, but they have to
then
follow
in
the
that
system.
case, if you are saying that the GMC does not have the power to give it, the same will be that the GMC can't also reject it. So
Hearing
in
will be
fact, the allotment was made to you was wrong. What do you
No, Lordship, the nodal agency as fixed by the Lordship central government.
Yeah.
That gives the different directions, sir. They have not followed it. This way we had some other time.
The individual hearing with the best option, well, ultimately those persons who actually need it, they will come before the hearing. matter.
Huh?
Ultimately, some person may have
No,
returned to
the
the
scheme
original.
will be implemented to a state level nodal agency designated by the state. Will entirely perform appraisal of so-and-so, obtaining sanction of the state level so-and-so, management, release of funds, management of revolving monitor, implementation of reforms of so-and-so. Where is the power? To allotment who will make?
Nothing is given in by the GMC Lordship or at page 22 Lordship, the scheme provides clause number 4.2 provisions of the basic services to urban poor, including security of tenure
at the affordable prices, improved housing, water supply, this is sanitation and ensuring delivery through convergence of other already existing universal services of the government of education, health and social security. Care will be taken to see that the urban poor are provided housing near their place of the occupation lordship. Nothing they have followed. This is the guidelines lordship, which starts from page 21, given by the central government. So they are the allottees, they are the purchasers. They have paid the affordable prices. Lordship, please to come to page 27. What are the duties of the nodal agent given in the central? After handing over, the GMC is bound to execute a registration till the registered sale.
Where is it?
Page 30. Last line. Last para, Roman
32.
32, Lordship. Last line. Realization of stamp duty to bring it down to be more than 5% the mission period, within the mission period. They had to execute a sale deed in the name of the allottee.
Who will make the allotment?
That Lordship, it's a APS Lordship nodal.
In the
For me,
page
behalf
number
of-
33,
Where is
there
the
is a note.
appointment of? Huh?
In the page number 33, there is a note. Down below, my lord.
Hmm.
State
State ULB urban level body will be required to implement the mandatory reforms.
So it is not clear.
Understood, but can the AMC allot?
That particular line I am also not.
Lordship, page 27, nodal agency, what are functions, Lordship?
That is there.
It is there, but allotment or cancellation power is not.
Where?
Lordship, page 27, last
27 there is a-
paragraph, nodal
Yes, it is
agency.
That I
It
read it.
would be implemented through the state level nodal agency designated by the state nodal agency who would inter alia perform role and
No,
function.
it would entirely perform following functions. That means these are the functions.
Yes.
So nothing more than that. Where is the power to allot?
But they have allotted Lordship, they have taken money.
So if the
And they
power is
cancel
not there
without-
to allot, the power is not there to cancel. So if there is no power to allot, then matter has a unnecessary, they've been there for 11 years.
That particular line I could not find it.
Find it out. We'll take it up
Right.
on 7th. Huh?
Not to put any other than 7, my lord, let it go.
Okay, then we'll have it on 11th. These matters have to be finished.
Right.
2013 matter. Look at what Mr. Roy is having facing a lot of problems.
Many times this matter was heard, Lordship, but
Then it is not required to be heard any further. What is there to hear? Either to remand it back. If there is no power, however, if there is no, but you pay your court fee then. List the matter again on 12th of September 2023. It has come up for hearing.
very.
Hearing. Yeah, yeah. On which date? The Learned Counsel for the GMC shall produce the records as directed by this court earlier. So, the Learned Counsel for the parties shall also indicate no, full stop. Be that as it may, taking into account that only the court fee of only one petitioner has been paid, although there are numerous petitioners, the Learned Counsel appearing on behalf of the petitioner submits that he would pay the deficit fee on or before the next. Huh?
All on 12.
Well, yeah.
Analogous.
Analog.
Yes, yes. Two petitioners. And in one case, two petitioners, then you pay 2 fees. So you pay the other. Everybody has a different allotment. Can't have it. Well, yes, order is required because what is happening, the registry is not looking into it. Nobody, the lawyer, the councils are not paying for this order is being passed. I'm talking one single order for everybody. Whereby saying that there is one petition, that only court fee of only one petitioner has been paid, but there are other numerous for which the Learned Counsel appearing for the petitioners undertakes to pay the debt.
37.
Mr. Dasgupta, kindly give your names also, huh? Ask your, put it in that list. Then what matters? No. Yes, Mr. Sean. What is there to take up this matter now? Which year? 13 को आगोते आना है.
Okay.
Take it some other day. Get a date.
What?
ঠিক আছে